Good morning. My name is Adelina Simpson, and I'm co-chair of the Education Committee. It's my pleasure to introduce our first speakers, Justice Henry Nowak and Judge Elena Kakavas, who will be speaking on ethical issues related to litigation and mediation during the pandemic. Justice Nowak was elected to the New York State Supreme Court in November 2010. He served 2 years as the expedited matrimonial judge and spent the next several years handling a wide variety of civil cases. In 2016, he was assigned to the commercial part, and since then, he has continued to hear commercial, matrimonial, and other general civil cases through the present time. Justice Nowak also served as a Buffalo City Court judge from 2003 through 2010. Before being elected to the bench, he worked as a trial attorney at Lipsitz Green and Connors and Villardo. I would also like to introduce Judge Elena Kakavas, who is the founder and principal of the firm Kakavas ADR LLC, specializing in arbitration, mediation, and workplace investigations of employee and officer misconduct, as well as claims of harassment and discrimination. Prior to founding her firm in 2018, she served for 25 years as an administrative law judge for the New York State Public Employment Relations Board, having jurisdiction over public sector labor matters governed by the Taylor Law. Judge Kakavas has presided over thousands of cases and issued hundreds of decisions, including matters of first impression. Prior to her appointment to the bench, she was a member of the labor group at Hodgson Russ. Both Justice Nowak and Judge Kakavas are graduates of the University at Buffalo School of Law, where they were both members of the Buffalo Law Review. And with that, I will turn it over to our speakers, and the program will now begin.
Okay. Can everyone see the presentation? Yep. Okay, good. So hi, everyone. My name is Joe Trapp. We're doing this as a panel this morning. I'm a member of the Gold Group, and I will be moderating this panel. Oops, here's my other control. Our panelists today were kind enough to send over some raw materials, which to make this all go smoothly, I put together into a PowerPoint. So any issues with the PowerPoint are solely on me. They don't represent the thoughts of any of our panelists. And the point of this today especially is to, apart from having a nice lively discussion to energize folks, we've got two highly experienced members of the bench and bar, and we've had some very unusual times. We want to be able to think outside of the box, and this is an opportunity to do so and think about ethics and what's coming at us now in a new technological world. So as mentioned today, we've got Judge Nowak and Elena Kakavas, who is now a retired judge and principal of Kakavas ADR. We've got myself moderating. We're going to try to split this up into 3 15-minute-ish presentations. We're going to start with Judge Nowak, then Judge Kakavas. I've got some questions that we'll be asking the two panelists. In the meantime, you can throw some questions in the chat. I'll try to incorporate them into my section at the very end, and we'll have that if there's a little bit of time left over. And let's begin. Judge Nowak, take it away, sir.
Thank you, Joe. And Adelina, thank you for the nice introduction of Judge Kakavas and myself. It's also so nice to see so many experienced members of the bar here. Talked about our experience, but looking around the Zoom room, we have people with more experience certainly than I have. So please feel free during the presentation to raise your hand or jump in with a question or interrupt me, and whatever you like, because really we'd like to tailor our comments to whatever cases you have or whatever issues you currently have pending, and to address those, I think, first and foremost. So feel free to do that. We're starting in terms of remote proceedings. We have the judiciary law up on the screen, and this has been cited in the handful of cases that we have in addressing whether or not folks have to come to court, whether or not they have to appear remotely, and to deal with remote proceedings. And we'll talk about a couple of the cases that have been published regarding those issues. The next thing that Joe listed on the PowerPoint is the ADA advisory memo regarding in-person appearances. And they talk about judicial discretion. at first, but it's interesting. You know, my reading of the memo is a little bit different, I think, than perhaps Joe's reading of it. And that is because it starts with this huge footnote. This little 2-page memo has this big footnote, and the footnote says, you know, these are the conditions that place people at greater risk of contracting COVID. And, you know, and it starts with cancer and, you know, other you know, diseases that, you know, we're familiar with and obviously of great concern about. But it ends with, you know, the use of immune weakening medicines. And if somebody, I thought about this, if somebody were to come to me and say, gee, Judge, I can't come to court, I'm taking something, any drug that they mention, and they say, this really weakens my immune system, what am I going to do with that? As a judge, am I going to go and research the drug and say, well, I think your immune system's just fine? You know, we're not going to do that. And so, so you read the list and you look at the footnote and you think, well, but gee, if anybody says that they have any of these issues or that they have a concern about any of these issues, of course, you really can't require an in-person appearance. And in fact, the memo goes on to say, you know, a person seeking an accommodation should not be required to appear inside the courthouse, and pretty clearly about that. And then, of course, an order granting or denying the request for the accommodation should be explained in writing or on the record. Now, as a judge, if I grant it, if I say, well, you know, you requested this accommodation that you appear virtually, I'm going to grant that for the reasons you said, for the reasons you just put on the record, or for the reasons you included in your letter or your email or however they communicated with me, that's a breeze, right? If I'm going to deny it, I have to give some sort of an analysis as to, you know, why I don't believe you, why I don't think it's reasonable, why you have to come to court. Much more difficult. And so by simply putting this requirement on us, it seems like, you know, nice, easy requirement. Oh, gee, make sure you put it on the record. It's not that to judges. Judges, when they read that, will look at that and say, hang on a second, this is going to be much more difficult. So basically, the takeaway that I have, I'll just note too, on the second page of that ADA memo, they talk about all the ways the court can entertain a virtual experience, how you can have substitution of counsel and other types of things. And they really make it easy for us to do it. In fact, they even say, gee, if you don't have evidence that you need to grant the accommodation, you can just grant it based on, you know, the word of counsel or, you know, good faith belief, and you can have the evidence presented later. I mean, they really try to make it as easy for us to grant these accommodations in this sort of little carrot and stick memo the way that I view it. So, so that's the long and short of it. If you or your opponent or your client or the client on the other side doesn't want to come to court, that's going to be granted. And I just think you need to know that going in. And I think you need to tell your clients that too. If your client says, I really want to do this in court, you got to caution them right off the bat that this is the current state of affairs and this is essentially what's going to happen. That being said, of course, and the CPLR 104, the last thing on this slide, you know, about we want to have just, speedy, inexpensive determination of every civil judicial proceeding. This is cited in a couple of the cases too. That's the other basis, because a lot of times the alternative is to say, well, let's wait until things get better. And some of the judges are different. I tend to be a little bit more optimistic from my peers that I've spoken to in terms of thinking, oh, gee, I think we're rounding the corner. I think we're doing well. I think, you know, the community's, you know, coming back. We're all going to get vaccinated. But there's other judges out there that do not have that approach at all and don't agree and just say, look, from what I've seen, what I read, the news I get, you know, we're going to have jury trials in the fall. I don't know. Maybe not till 2022, you know, and so it depends on who you talk to in the news you're getting. I have jury trials scheduled now starting in like May and June, but it's all, you know, with an asterisk. And the cases that I have that are definitely requiring a jury, and these are cases that I've been pre-trying for 3 years. I've handled motions, et cetera. We're at the, you know, we've done mediation, settlement conferences, et cetera. We know we're going to need a jury trial. I'm not even looking at the summer for those. I mean, those are, I'm putting on for the fall again, with the hope that these will be good dates to go. Any general questions about that or scheduling, or anybody want to share an experience they have that might be different with another judge?
And folks, you can try to put things in chat as we go along, and we will attempt to get to it. I know it's a little bit different in the virtual forum in order to participate, but we'll do our best. There's one question that came in here. What happens when both parties agree that they do not want to come into court, but party refuses to conduct an evidentiary hearing or bench trial virtually because the case is document heavy, and they aren't comfortable using the video conferencing technology?
I think what we'll see, and we'll get to this in the other slides of the case, the judge can require you to learn it, learn the technology. And, you know, and the types of accommodations we see in one of the cases we'll talk about, judge delayed the trial one day and said, first day that you were planning to try the case, I want you to work on getting used to the equipment and submitting the exhibits. And it was particularly about, you know, submitting exhibits in a case. It didn't seem to me that that case was all that document heavy, but it just seems that that's going to be the accommodation is, well, we'll delay it a few days or spend 2 or 3 days uploading exhibits, numbering them, making sure everyone's looking at the same thing. Because frankly, when you have a witness that you're testifying about and you're going through the exhibits, whether you have 3 or whether you have 300, you're going through them one at a time. I'd like you to look at 296. Everybody has 296, 296, go to the third line, you know, and that's how we do things. So if it's cumbersome, it's just going to add a little bit more on the preparation side, pre-marking essentially.
So, Your Honor, would you like me to go to the next slide?
Sure, thanks.
Okay.
Okay, rules to the bar, remember. There's the competence rule, and I'm going to just stop on this one for a second. Lawyers should provide competent representation, which includes determining the efficacy of appropriate technologies used in the practice of law. I mean, video conferencing now, I'm doing nonstop. I don't know about all of you, but I think the attorneys that are busy are also, because there's a lot of times I'll look and say like, all right, can we move this to March 19th at 2? And then 3 of the attorneys on the call say, oh, I've got another one. I've got a hearing. I've got this. So I think everybody's getting bombarded with these video conferences now. I'm still surprised. I'm not surprised from parties, but I am surprised by attorneys how much trouble we still have with the camera, the microphone, the internet connection, you know, bouncing in and out, you know, and some people will say, gee, I think it's Microsoft Teams because I don't have this much trouble on Zoom. And that's been my experience also, but Teams is better than Skype was. But I think a lot of times it's the equipment. I had an important oral argument recently. It went over an hour, multiple attorneys on the case, motions to dismiss, really interesting issues. And one of the attorneys from a large firm had 2 microphones and wasn't sure which one was the one that the attorney was using. And so it had this terrible echo, but the attorney didn't want to turn off either one because, and didn't really know how to turn off either one. So we just sort of endured it for, you know, I mean, the attorney's argument was probably 25 minutes. And it was difficult. And the court reporter struggled. And there were times when we like stopped and I said, gee, you know, I don't know if we got that. Can you repeat the last sentence? I'm kind of looking at the court reporter who really can't gesture because she's on her machine. So that's the kind of thing I think as attorneys under this rule, you really have to, if you haven't already, you really need to stop and just say, wait, let me get a tech person in here. And let me just make sure that when I'm having a video conference with the court, certainly if you have a hearing or something like that, I have a crisp, clear, loud, you know, camera with a good thing, good internet. I mean, just make sure. And if you make sure you're not blurry, make sure you're not glitching or freezing and moving, you know. And I think that I mean, it's trial and error. I mean, there are times when I've changed around where I sit in my home because I'm on a laptop now in my house and I'm right next to the router. My router is a foot away. My cell phone is further away because that can interfere. So it's like, you know, you have to kind of play with it sometimes, but do that effort. Set up a conference call with a friend or something and just make sure that you can get, and if you don't have the right setup, get the right setup. Because I think it's like having a pen and paper now. I think it's just necessary equipment for the next, frankly, going in the future indefinitely. So,
Your Honor, I'd
yes.
love to hop in right now if I can see if I get this to share. Can everyone see my screen still with Twitter Cat?
Everybody's seen the cat video.
So I think that, you know, based on your comments about technology and stuff, and I have another question I'll follow up with, but Oh, I wish this wasn't blurry, unfortunately, but it says here that you shouldn't be recording this, and you can see that this screen down here, for those of you who aren't aware, this was a lawyer whose child had put on a cat filter, and this lawyer didn't know how to take off this filter. It already has over 34 million views. So I thought this might be a good segue, Your Honor, to talk about instances like this. But I also wanted to ask a question that, because so much of law is optics, especially when you're in trial, especially when you're talking jury trials, are lawyers, in order to preserve their ethics, to show their clients in the best light, is it going to become like the play Chicago? Are we going to have to razzle dazzle them? Do we have to start setting up full studios so that lighting can be right and the microphone has clear audio, so we have professional microphones? I mean, how far does this go for us to meet our ethical burden?
If it were me in my practice, I'd go all the way. I don't understand why you would rent, an office space that has a nice conference room and a nice table before you would do this. I think you would do this first, do the internet stuff first, make sure your internet connection, make sure your background, your microphones, cameras. I would do that, I think, before anything. It's just become so important, and it's so common now. I mean, that's how we do 90% of our work now. So.
And based on that, Your Honor, because we're talking about that razzle dazzle. I mean, I remember Richard Gere looked wonderfully. We just had a question come in. What's the dress code for remote court proceedings?
Depends on what you're doing. I think that obviously for anything on the record, even just an oral argument, you're definitely like you would be appearing in court. I don't put my robe on, but I usually put my suit coat on when I'm hearing oral argument. And I'm usually doing it from my desk just so that I can use the camera closer, but I'll keep the camera on in the courtroom as well. And I can jump out into the courtroom and use that if need be. It's just the parties can't see my face as well. And I want them to see my reactions, because sometimes during oral argument, an attorney will argue something and I'll make a face and they'll be like, well, Judge, they'll tailor their argument. And I want them to do that. I want them to be able to react to sort of because I don't want to interrupt the attorneys either, if I can help it. So that's why we do it. But as far as conferences go, I'd like the attorney to have a shirt on. And that's it. And the cat filter would be cute, but you got to make sure you know how to turn it off. I don't know if we need to focus too much. I mean, these are the other rules. Security of the call, I think that, at least as far as anything generated by the court, I think we deal with that, enforce that too. But for meetings with clients, I mean, the security is something you need to be on top of as well.
Absolutely. Okay, let's go to the next one. Here we
go. These are the cases that I just included in the materials, and you can take a look and read each one if you have them. People v. Cintron, the one in the middle, I'll just talk about very briefly first, regarding the televised testimony from a child witness in a separate room. And then it talks about, if you have that circumstance, I would read that case and kind of go through it. And it talks about the disadvantages of doing that, but not prejudicial. Again, this whole notion of can we hear the witness? Can we evaluate the witness's demeanor? And a lot of that depends on where the camera is. And keep in mind, I mean, in all of these platforms, we can set the gallery in such a way that the speaker's face is really the whole thing on the monitor. And if you've got a big monitor, I mean, you can actually have the person's head be larger than it would be in real life, and you're 2 feet away now. So it's almost easier to evaluate a witness's demeanor in this forum than it would be on the witness stand, where they're parallel to you. And I'm kind of looking over and I only catch half the side of their face. I mean, the jury has a little better view by design, but that's the thing to kind of keep in mind, is that when you're talking about demeanor. And the other case that spends a fair amount of time, I'll talk a little bit more about Bonilla, the first one, that talks about being able to gauge the witness's demeanor. Bonilla was a case that was decided 2 weeks ago. It was, and the issue that we had in it, it's a court of claims case. Luis Bonilla sued the state for a wrongful conviction. The offense for which he was convicted of was caught on video, and the date of it was January 8th, 2012. So we've got this 8-year-old video. And interestingly, it was caught on by two different cameras. At wherever the offense was, had like 2 security cameras. So we have these 2 video feeds of what happened during the alleged offense 8 years ago on these 2 screens, video 1, video 2. So, you know, this is something to keep in mind about Bonilla, and this is sort of the rule. If you're going to do a hearing, your hearing is only as good as your weakest internet connection. It's like, you know, it's that same cliche that applies to, you know, the weakest link in the chain kind of thing, but it's true. And frankly, I'll go even one step further from my own personal experience. Your hearing will be only as good as the desire of the participant who least wants to participate in the hearing. I had one where the person didn't want to appear, and every time a little technical glitch came up, oh, it's the end of the world. Oh, we can't go forward, because, you know, they're just looking to sort of get out of the hearing in the particular case. So you have that dilemma as well. But what we had in Bonilla, the judge had a conference on December 14th, again, just a couple of months ago, and set the trial in this case just on liability for whether there was a wrongful conviction this coming May. So it's set for trial this coming May. A week after, and apparently the attorney for the state, the assistant attorney general, objected at the time of the conference, but then put it in a letter a week later to the court as to why he objected to conducting the trial virtually in May. And the reasons that the attorney gave referred back to the deposition they just had on December 3rd, a couple of weeks before the attorney wrote the letter, like a week and a half before they had their conference. And what the attorney explained was that they basically had 6 screens going, 6 images going at the time. They had video 1 and video 2 because the attorney's questioning Mr. Bonilla about what happened back in 2012. And they're like, you can imagine this, like sort of freezing the video at this moment, well, who's that, who's this, what are you doing in this? Trying to show the video. So you got 2 screens for the video, screen for the assistant attorney general, screen for Bonilla's attorney, screen for a Spanish interpreter too. And then screen for a court reporter. So that's actually 7 screens. And then the screen for Bonilla. Now, Bonilla's screen was at his daughter's house because she's got the better equipment, right? Weakest link in the chain. But every time his daughter got a phone call, it interrupted the deposition. So, you know, I mean, she may have a friend that's calling in the middle of the day to see how she's doing, and that interrupts this whole 7-screen proceeding trying to interpret this video and everything else. And the attorney explained to the judge, I couldn't really see the claimant's face to assess credibility as we're going through the 2012 video, particularly when you have this delay also with the interpreter and everything else. So that was essentially the objection. The judge wrote in a really fine decision that he had the authority to order the trial, kind of got over that kind of quickly. And he relied on some of these other cases to do that. In fact, he cites 6 cases to talk about that on page 4 of the decision. But the bigger issue the judge sort of struggled with was, should I? I can do it. I can order the virtual trial in May. Should I do it? And then he said, I find the arguments made by the assistant attorney general to be unconvincing. And he talked about waiting out. He said, what's the alternative? We have to wait out the pandemic, and how awful that was. And this judge took a grim view of the future, opposite of what I would do. He talked about the new strains of the virus, the waves of infection. He talked about, the uncertain vaccine distribution. All of that's in this decision. And so he said, that's just absolutely not an alternative. As far as the, interruptions of the daughter's internet service or with the phone calls coming in, he said, you can do that by just adequate preparation. And here in Erie County, one thing all of you should know, for all of the witnesses, parties, et cetera, the grand jury kiosk is set up just beautifully over at 25 Delaware. And it's a room where you go in alone. So if you have a client that says, look, I'm using my phone, I don't have good internet access, I don't know where to go for this. If you say, well, look, can I reserve the grand jury kiosk? I've tried to reserve it 6 or 7 times in different cases since May, and it's been available every time now the grand jury wasn't in session for some of that, but for a lot of it, but still, if we need to find another room at the courthouse to set up an internet connection and a wired connection with a laptop, that's something that we can do. That's relatively easy to do. So that's what this judge kind of relied on and said, look, we can have Bonilla for his trial in May. We can have Bonilla in a different place with a better connection, better everything, no interruption, et cetera. And the other thing the judge indicated is that he disagreed that he had an inability to assess credibility. Again, maybe the same thing I was talking about before, where you're looking at the person straight on now on their face. The camera's right in their face. And the one thing the judge didn't mention that I thought of when the judge was addressing this in Bonilla is, you have that disclaimer that we had today that, you can't record this proceeding. The attorneys and the parties can't do a separate recording, but the judge can. I can record everything. So if I'm recording a conference, I can record a conference. If I have something where I want to go back and look at exactly what the person said and how they said it, if it's a hearing, I can record that and I can look at it 10 times in a row. So the judge has that option. And of course, the judge, as I mentioned before, can change the view so that the person's face is right on the whole screen and everything else. So it almost is a little bit easier in regard to addressing this whole notion of, well, I can't see the witness, can't address their credibility. It's certainly easier for the judge. The argument that it says, well, judge, that's great. You're going to record it and go back and blow it up and all that. I can't do it as the questioning attorney. And I'd like to be able to see it. I think that that's still a fair argument, but yet, something that is going to probably not be ultimately successful in court because the judge is going to feel that he or she can do that. Okay.
Actually, Judge, let me hop in right there. Judge Kakavas, is that the same thing in ADR? Can the arbitration panels, for example, record and view later while they're looking to make the decision, or?
Yeah. Yes, the arbitrator is the host and the administrator of the proceeding. And so the arbitrator can make the decision to record, but has to prohibit everybody else from making a recording by any means. And I begin with a set of ground rules. And one of the first ground rules is you can't record on the computer. You can't record on any ancillary device either.
Well, that's interesting because I know we've got cases here at our firm that have gone multiple years. And basically, in my humble opinion, I think things get decided on the papers at that point. But if things can be recorded, I think it really strengthens the oral argument. That's really interesting. Okay, I did not know that.
The problem with recording is, at least in arbitration, goes to the issue of confidentiality and the ease with which then what happens during the proceeding can be shared with other people.
Okay.
When I do, I've only recorded things that where I'm a mock trial coach, so I've only recorded my students like practicing for mock trials. My only experience with it. But when I hit record on Microsoft Teams, it asks me where I want to save it. And I save it on my hard drive on my computer in the office. And that's where it is. So it's not saved in a cloud. It's not saved on even a network that could be at some point. So it's something like that. And if judges start to get familiar with doing that, I can certainly envision in the future recording an oral argument that I may want to go back and review on a particularly important case or significant case or something new. And so again, when we talk about, gee, should I set up a studio in my office? Maybe you should, because maybe the judge is going to record it and play your argument 6 times. Some judges, I don't know if they consider oral argument to be as important. Like you said, Joe, a lot of judges rule on papers. Boy, for me, it's a big deal. For me, I can't tell you how many cases I've had going in oral argument thinking I was going to rule one way and then posing a couple questions and an attorney explaining it well, and I go the other way. It's a big deal. So I'd be ready. I think that's part of your responsibility now, even ethically, as an attorney, to present your client's argument in the best light.
Well, geez, I'll have to go visit our friends at Hunt then, because I think I only have one ring light here.
Gotta get 5, 6, no, whatever really presents it well. The last case that Joe cited is a matrimonial, and it was at the kind of the tail end. It was like one of the last things that the judge decided. Judge had already decided equitable distribution by this point. This was a contempt motion made by the wife against the husband for deleting his spyware. And it turned out if you read this decision, they had many go-arounds concerning spyware in this case over and over again throughout a couple of years. So the judge was pretty fed up at this point, but there was a request by the husband to say, I don't want to have a virtual conference. And the ruling was similar to Bonilla, where the judge said, interestingly, the judge said, I would not direct the plaintiff to participate in an in-person proceeding. The judge kind of made a point of that, saying, I'm not going to make you come to court. But then, of course, did direct it. No, we're going to go forward on the virtual. And this is the one where the judge gave the 1-day delay because they had evidence issues in terms of spyware and other stuff. And they said, we're going to give counsel time to assemble evidence, submit it under the protocol. I think the judge attached the protocol and also indicated that he or she, I forget the the gender of the judge, but would allow reasonable requests to allow counsel and the parties to speak privately. And so that's something, you know, that we do from time to time too. I've had even conferences, just settlement conferences with parties where then we sort of stop the call and say, all right, let's come back in 5-10 minutes. You use your cell phone, call your attorney privately, make sure you mute, you know, that kind of stuff. So that's fairly routine. Okay. And with that, I'll turn it over to Judge Kakavas or anyone who has a question, I guess. Or Joe, back to you.
You're muted, Joe.
I think you're muted. See, this is what happens.
Okay, whoops, there we go. So yeah, I think we were going over strategy, so that extra slide was extraneous. Before we get over to Judge Kakavas, so I wanted to take a quick second, because I'm not sure everyone has been following what's been going on with the courts and what Chief Judge DiFiero has been doing over the last couple of years with COVID. So what happened was, where's my notes? Here we go. Basically in 2000, they published in February of 2019 an interim report and recommendations of the statewide ADR advisory committee that was basically summed up everything that had happened during 2018 when they had a whole bunch of meetings to try to figure out how ADR was going to move forward with the court system. Because as everyone knows, some courts have a decent backup, and ADR is being looked at as a really good way to help relieve some of that burden. So there ended up being a statewide office of alternative dispute resolution was created to assist local judicial districts in implementing the program. A central tenet of the program was flexibility on district-wide basis, and even among judges themselves within the district, to conduct enhanced settlement conferences or to directly refer cases to mediation, arbitration, or just neutral evaluation. And we can go on about this, but the bottom line is that all the judges ended up receiving training under this program as well to try to implement this program. And so before we switch fully to Judge Kakavas and how she's views this new expansion and how it fits in with what was going on before, Judge Nowak, I was wondering if you could touch on some of your training under this program and how that affected the way you run your court.
Yeah, oops, I'm not muted. Okay, yeah, I had a fair amount of training in mediation when I was in the commercial part as part of that. But now mediation training is a regular part of the summer seminars, which were done virtually last year. And I also noticed that the mediation and ADR training is part of the new seminars that were just issued for first-time judges. They do, you know, initial judges school, initial seminars, right, when a judge starts every year. And so it's becoming more and more part of the regular curriculum that we're seeing. It's not like they're doing as many, you know, separate seminars, although there's some from time to time, but it's part of the regular training that judges are having. In addition to that, what we are getting encouraged a lot is to try to recommend cases. And we have a new program now where when I have my first conference, preliminary conference, there's a form I need to fill out that says, what is my plan for ADR on this case? And so I'll bring it up. And if John Ziegler's handling the first conference, my law clerk, he'll bring it up. What do you want to do with settlement? Is it worth it talking about it right now? And a lot of times the cases, the attorneys will say, gee, let me do depositions. I'm not ready. We can't do anything. Let's go. And we say, fine, that's okay. And we might do a scheduling order. What we'll say after depositions, we're going to then have a settlement conference or a conference to explore ADR. And that may be a referral to the Violani program on the 10th floor of City Court, to either, you know, Melissa Nixon, John Gorman, one of the court attorney referees up in that program, or it can be something where we can explore private mediation. So, gee, have you looked at rosters of mediators? In the commercial part, we kept a roster of, I think when I left the commercial part, we had 16 mediators that had already been trained, and there's criteria and training for them. But we're starting to see that now in other areas too, where we are starting to keep lists of mediators. And it also doesn't bar any of the attorneys from saying, I want to go into private mediation, we're going to pick our own. And there are people in Western New York that are doing that and do a really nice job.
And Judge Kakavas, I remember you telling me about how hard it was to be registered or certified as an arbitrator, and perhaps that's a good way to kind of move into this, the process of kind of starting this. Actually, we should probably hop over to our next slide while we're at it.
Okay, well, certainly ADR is nothing new. We can trace it back thousands of years to ancient Greece and Rome. Aristotle and Cicero both spoke of it, and the current usage of the term mediation and mediator as someone who engages in calm thought goes back to the 14th century. So the process of mediation, of course, is facilitating a mutually acceptable vote. Arbitration, of course, moves the discussion to a hearing overseen by a facilitator rather than a decision maker. And throughout my career, both as a practitioner and certainly now, I've referred to arbitration as litigation in a particularly friendly forum because of the relaxed rules and the emphasis on getting to a decision or an outcome on an expedited basis. Arbitration also goes back to the ancient times in ancient Greece when the courts were crowded. Interestingly, the city-state of Athens created the position of public arbitrator, which every male at 60 years old had to engage in when parties wanted to elect to proceed with civil cases in an arbitral format. Now, if we fast forward to the late 19th and early 20th century, we see the creation of modern day ADR. So in 1888, the Arbitration Act was passed. The focus then was on railroad disputes. In 1926, the American Arbitration Association was formed, and the focus throughout much of the 20th century was on labor. But in 1975, the AAA was expanded to broaden the realm of the cases it got involved in. In 1979, the much acclaimed Harvard Negotiations Project was created, and a few years later, ADR was popularized by the creators in a book called Getting to Yes. In 1990, the Civil Justice Reform Act initiated experiments to reform the federal courts with a focus on ADR use. So let's move to the next slide. All right, and we consider then COVID and its impact on ADR. So courts have been historically backlogged. We all have knowledge of that. And in May 2019, the New York State Unified Court System and Office of Court Administration announced an initiative called Presumptive ADR to integrate ADR into the civil court system. So ADR was already being looked at as a solution to judicial overload well before COVID. However, now with COVID, of course, it's very clear to all of us, the courts have ground to a halt largely, and there is a slow and partial reopening as we try to resume business. But the parties in civil litigation clearly are facing long delays. And so there is the option for them to either agree to take their cases to ADR or be ordered to do so in some instances. So the first step of ADR is, of course, mediation. It's been said that an ounce of mediation is worth a pound of arbitration and a ton of litigation. The benefits of mediation, well, costs are generally split. They're generally lower because the time is significantly less than informal litigation. And although a mediated agreement is binding and fully enforceable if it otherwise satisfies the requirements of a contract, it's not always necessary, and in fact, pretty rare to have to go to court to order compliance. And that's because of the control that mediation offers. So the parties are defining the four corners of their agreement and what they can live with. Of course, that's very different from court where a judge decides, or even binding arbitration where an arbitrator is deciding. And the other big benefit of mediation is confidentiality. Proceedings are strictly confidential. In fact, that concept is so important that in most cases, the legal system can't force a mediator to testify in court. And in fact, most mediators destroy their notes once a mediation is completed. The exception, of course, is child abuse issues and threatened or criminal activity. To the next slide, if you will, Joe. So how is mediation regulated? Well, the bad news is there is not one centralized entity that does that. The good news is that there are a lot of different entities which offer direction. So on the screen, you see a few of those, the ABA, MEAC, and local rules of conduct. Also, most mediators are attorneys. And so, of course, they're still bound to the ethical rules and standards of conduct that the ABA and state courts have, state codes have directed. When you look at all of these entities giving us guidance, there's three main areas of focus. One is on confidentiality. The other is on protecting the integrity of the process. And the other is protecting the underlying concept of trust in mediation. So if we move to the next slide, we look at some of the guidance given by the Mediator Ethics Advisory Committee. MEAC was created in 2006, and it has three major objectives: to respond to mediators' inquiries, to promote professional development and consistency in the field, and to recommend mediator standards of conduct. Now, the cases that are on the screen are there because they give you a representative example of the types of opinions issued, which do go to the three primary issues I just mentioned. We don't really yet have a lot of guidance on COVID or post-COVID issues. So let's just talk about each one of these because it'll give you an idea of the framework within which ethical concerns operate in the mediation context. Opinion 2015-01 had parties requesting to videotape a mediation. And as you might guess, MEAC said, no, that can't happen. It shouldn't happen. It goes to the core of confidentiality. And certainly it undermines the efforts that mediators take to protect the confidentiality, going as far as to destroy their notes. In opinion 2006-02, there was a statutory rape revealed during mediation. Well, there MEAC said that's reportable due to the child abuse exception to confidentiality and non-disclosure rules. In opinion 2008-02, there was and actually I think this is kind of an interesting, surprising outcome. There was a topic involving attorney's fees, an attorney fee dispute. And the mediator became aware that there was a court regulation that had an affirmative disclosure requirement that the attorney had to tell the client they could go right to arbitration. And MEAC said there was not an obligation on the mediator to disclose knowledge of that rule to either party. In opinion 2013-01, a party to a mediation was using it for discovery rather than conflict resolution. MEAC said the mediator had to intervene immediately because it was basically an abuse of the process, and it referenced the ABA model standards of conduct for mediators in making that ruling. And in opinion 2010-01, it was discovered that a party was recording a mediation and surreptitiously. And MEAC said the mediator had to stop the proceeding immediately and had to disclose exactly why that was happening and then report the conduct for possible sanctions. Now, there are no national rules on confidentiality. The courts have to adopt local rules for that in our ADR proceedings, but most local rules do not apply to private mediations. That rather is governed by contractual confidentiality obligations. And in fact, pretty much every mediation begins with the parties being required to sign a confidentiality agreement. And of course, failure to participate in good faith in a court-ordered ADR procedure can be interpreted as failure to obey a pretrial order and is sanctionable. Move to the next slide, Joe. This is again the types of ethical codes and standards of conduct that are applied to arbitration. Basically, we're moving to a hearing process, and so there's a broader range of ethical concerns. But before we go into that, I want to share with you some data which illustrates the benefits of using arbitration to relieve the courts. Toyota released a study that showed that with ADR, there was a decrease in the number of court cases from 178 to 3 over 7 years. And AT&T released some data that said that the number of filed lawsuits decreased from 263 to 28 over 9 years using ADR, and legal fees decreased by 50%. In fact, in 5 years, it said that it had spent less in settlements and arbitration awards than in one court case. The AAA, the American Arbitration Association, has also provided some data that's interesting. With ADR, 65% of cases settled versus 29% without ADR. 12 hours was the average prep time for ADR and 7 hours in the actual process of a hearing, compared to, which was estimated to save 88 hours of prep time and 6 months of litigation time. And in New York, where appeals are heard in the Second Circuit, it took 29 to 40 months longer through court than through ADR, 45.7 months compared to 12.2 months. So the data shows that indeed arbitration is faster, and that then translates into cheaper. When we consider ADR and arbitration, particularly in the context of COVID, people have drawn an analogy or some guidance to consideration of the recession of 1990. So during that, state trial court filings increased by close to 1 million cases. And in federal courts, bankruptcies doubled, adding 700,000 more cases. So the prediction for COVID is, of course, to see a huge increase in docket spikes because of the social and economic ravages of the pandemic. So consider that impact in light of an already backlogged system, suspended cases, and the moratoria on foreclosures and evictions. So the biggest change, we're going to see ADR, and we're going to see that because of the restrictions of the pandemic in the context of virtual proceedings. But I think ultimately the flexibility of arbitration and improvements and more comfort in using technology will make ADR even more valuable. So the biggest change, I think, is going to be the remote proceedings. I think that may increase access to justice, but I think there are huge ethical challenges and practical considerations. We're starting to see ethical guidance from the various administrative agencies like the AAA. What are the key concepts? Of course, confidentiality. It's not automatic in arbitrations. It's often part of an arbitration agreement, sometimes part of court rules. The AAA and the ABA have developed ethical rules governing the obligations of arbitrators to maintain confidentiality of proceedings from an administrative standpoint. I think there's also concern, of course, about cybersecurity, although I do think that both the issues of confidentiality and cybersecurity will become less concerns as platforms become better encrypted and more advanced, and also as we get more and more guidance as to best practices. There's a question of who has responsibility to ensure security of hearings. I think it's a joint effort, but I would argue that the greatest burden falls on the arbitrator. I think, though, that the costs associated with technology and security support should be shared by the arbitral institutions. And of course, as Justice Nowak mentioned, there are due process concerns. This alleged inability to present cases effectively and examine witnesses, I'm sure, is going to come up again and again. There's an interesting situation going on in New York State with teacher discipline cases. So those involve a teacher maybe losing his or her license, losing his or her position. So there are property interests at stake, big due process considerations. When I tried those cases, I often thought they were very much akin to criminal proceedings. But the statute in New York does not, that governs teacher discipline, does not speak of in-person hearings. Now, historically, though, that's been taken for granted. Interestingly, one of the largest teacher unions is challenging the virtual setting and refusing to participate in virtual proceedings. Now, what's that doing? That's creating a huge backlog in those cases, which are already enormous. And there's the ethical issue of the costs that then puts on the district and in turn the taxpayers, because teachers have to be paid while these proceedings are pending. So absent express language in an arbitration clause or a statute, is there a reasonable expectation to a hearing in person? Well, Not necessarily so, but what we're fighting is the historical expectation. There's also a question of whether or not the virtual hearing breaches the level playing field between the parties. So a fundamental principle of arbitration is equal opportunity and equal treatment. Well, we can't assume that everybody has equipment and can handle technology effectively. And I think we're going to see those issues raised in challenges in enforcement proceedings. So I think we all need to be concerned whether that's going to widen the gap between the haves and the have-nots. I think there has to be focus on how we treat in the remote setting coaching of witnesses and protect the integrity of the process. Certainly sanctions can be resorted to, but I think it's hard to decipher what's going on when you have a number of people in different settings and you're seeing faces on a screen. I think the best practice, at least for now, is to warn people ahead of time with ground rules about what you expect during the hearing process. So what's crucial as ADR and virtual proceedings become more used? Well, I think you need a proactive and organized panel of arbitrators to take command of proceedings from the start. I think respect for the process has to be enforced. I think to some degree, the same decorum that is expected in a court of law should be practiced despite the rapidity and the flexibility of the arbitral forum. And I think the organization of the person in charge is key, and that goes to consideration, for example, of determining when a case is ready for ADR and not sending something forward before that makes sense. For attorneys, I think preparation is the key. Take advantage of the fact that arbitration is highly customizable, but recognize that it is an expedited process that will go to your ethical requirements of competence. It could very well be a few months from an initial submission to a hearing. I think there's tremendous importance in the pre-hearing conference, and ground rules are very, very important. I think most arbitrators develop their own. There's been tremendous training since we've moved into the virtual format. And I know one of the first things I did was developed a list of 30 ground rules that would govern the arbitration proceeding. I think there are going to be greater obligations on attorneys, and this was touched upon in some of the earlier slides, but I think attorney competence is now going to have to include determining whether or not technology is appropriate for a case, how best to use it, and how best to argue against it in legitimate and defensible ways if you think it isn't appropriate. I think due diligence is going to include understanding the risk to competence and confidentiality in the virtual forum. And I think that due diligence is also going to include effort to enforce compliance with ethical rules by the people you are with in the virtual setting. And I think attorneys have to be concerned with security and take appropriate and reasonable measures to protect the client's confidentiality. I think for neutrals, there's going to have to be greater standardization of qualifications, perhaps more mandatory training, although maybe experience can waive you out of that. I think there'll have to be a detailed screening of cases when you're talking about ADR working in with the courts, and a determination of what cases are likely to benefit from ADR and which are not. I think there will have to be concrete timeframes for case movement so that the expectations of everybody are clearly known and cases are not stalled. And I think that there has to be an assignable structure. So there's a determination of what cases would be benefited by mediation, what cases need a structured conference, the more complex cases, and what cases could go to expedited trials and arbitration. I think we're going to have to need to assimilate new professionals and new technology into the systems. I think we'll need to see technology that is not only easier and levels the playing field, but also technology that's available to the have-nots. And here, I'm concerned about the difference between the big firms and the deep pockets in litigation that can afford a lot of sophisticated technology and the many people in the system who can't. And along those lines, I think law schools are going to have to better train graduates to use technology generally and to serve the disadvantaged. And maybe what we'll see from this is more opportunity for a younger generation of lawyers to move more quickly through the ranks because of their ease with technology. So I think there's a lot of issues. I think there's a lot of opportunity if things are handled correctly. I think the ethical concerns are going to be greater and quite challenging. But as Churchill said, let us never let a good crisis go to waste. So there's a lot we can learn and a lot of potential benefits to adjudicating in this new legal landscape.
Perfect. Thank you, Judge Kakavis. The next slide, folks, was going to be really some targeted questions I had. I'm actually going to save those so we can pepper our speakers at the Q&A session at the end because we're running tight on time. So I'd just like to thank Judge Nowak and Judge Kakavis for taking the time this morning. And please do continue to send over other questions to me. I am monitoring it. Meg's monitoring it, and we'll be sure to get to them. But just between now and then, here are some topics that we were looking at for this presentation in particular, but I think would apply to all of the presentations today. So just start thinking about these types of things, folks. Well, thank you so much, and I will pass it back over to the co-chairs for this panel, and excuse me, for this committee, and they'll introduce our next speakers. Thank you, everyone.
Okay. Before we introduce the next speaker, I just wanted to announce the first course code for the CLE, and it's the word mediation. And we'll also be putting it in the chat. Again, the first course code is mediation. Okay. Now I would like to introduce our next speaker, Paul Isaac, who is the founder of Paramount Settlement Planning, LLC. Paul Isaac is a former practicing trial attorney and a past president of the New York State Trial Lawyers Association's Western Region affiliate. For the last 21 years, he has been a licensed financial planner. In 2003, he merged his background in law and financial planning to specialize in settlement planning, founding Paramount Settlement Planning. Mr. Isaac is also founder and chief counsel at Precision Resolution, a national lien resolution firm. He also has earned his designation as a chartered special needs consultant. Mr. Isaac is a graduate of Duquesne University School of Law. And with that, I will turn it over to Mr. Isaac. Is it frozen? Oh, there you go.
All right. Okay. Are you able to see me and hear me?
Yep. Perfect.
Great. Because given Judge Nowak's high expectation that he set in his presentation, I'm a little nervous, I have to be honest with you. So we'll do the best we can here, and forgive me for any drops that may occur. So this is always a little disconcerting to me anytime I've been asked to talk about ethics, and I do so several times a year. And I'm always afraid that attorneys are going to think that I'm, lecturing them on ethics. And the reality is things happen every day. People don't always think things through. And hopefully, maybe this presentation will have something to do with remedying that. But I'm not lecturing. I'm just presenting. With that, let's get started on our presentation today. It's called, let me get it up on the screen here. Share screen. Be patient, Judge, please. Share screen. And here we go. All right. I'm hoping my presentation is up.
Yep, good to go.
And let's get this going here. Slideshow. Are you seeing the whole present? Are you seeing my notes on the side here, or are you seeing just a slideshow?
I can see the PowerPoint with the notes on the side, but I can't see your notes.
Okay. Well, something's.
Normally, there's a option at the top that will
Yeah, I
allow you to
see.
switch. If you're using multiple screens, it'll allow you to switch over.
Okay. Slideshow from the beginning. Let's go. Custom slideshow transitions. View.
Do me a favor, Mr. Isaacs. The bottom right next to the Zoom bar, you're going to see a little, looks like a podium stand. So down to the bottom of your screen. Here, actually, view options, where's remote control, request.
Joseph Kraft is requesting.
Yeah, because I'll click the button for you then real quick. Sorry, folks, minor technical difficulties. We'll fix it in a second. Okay. It should be fine. I mean, we'll see this thing on the side. If you just click on if you just hit the down arrow, you should be fine. Don't worry about it.
Pretty good. Let's get started. So, ethical pitfalls arising out of the settlement of personal injury cases. What does that mean? When does it happen? When are there problems? Some of them are very, very obvious, yet some of them are very obvious, but occur frequently. Some of the problems occur frequently. And when I say that, I'm talking particularly about the conflict of interest. Okay, the conflict of interest occurs. I'm in a situation at least once a week when I see this happening. There's a limited coverage available, and there's a parent and a child, or a parent and a child, and the father is the driver. So we have these multiple plaintiffs, and there's limited coverage. And the ethical rules really do prevent you from going forward representing all the parties without a proper acknowledgement from them that they are waiving their conflict if there is a set limited policy. It's different if you have 25 and a 25 and a 50 limit. But if you have $300,000 that's available from a driver of a truck, and you have to make the decision to divide it between the parent and the child, it is very dangerous to go forward in that scenario. And most of the time that this occurs, it is a situation where the allocation that is done by the plaintiff's counsel, who represents both, is perfect. It is exactly, in fact, there's always a presumption that more money is going to the child than should, given their comparative injuries. However, the child can never waive that conflict. So Rule 1.7 says, except as provided in paragraph B, a lawyer shall not represent a client where a reasonable lawyer or disinterested lawyer would conclude that the representation will involve the lawyer in representing different interests. And so that's a problem that occurs. Don't do it because the judge has the ability to say, you know, this is bad, and I'll get to some cases quickly. This is bad. We're not going to allow this to happen. So, situation, the case of Sheik versus Waiters from 2000, New York Supreme Court. The plaintiff attorney was disqualified from representing either the infant plaintiff or his mother, even though mother was represented by separate counsel on a counterclaim, because the same attorney could not properly represent potentially differing interests of mother, driver, in the not possibly consent. So you really have to be careful in those situations. We've seen cases that have not been reported, but where fees have been taken away and the attorney's been disqualified. Again, it's ugly for me to present this, but it does happen. We know it happens, but be very careful of that. Here's another case where the attorney violated disciplinary rule 1.1-2 and two others when he executed a retainer agreement with the driver and the passenger who were injured in an automobile accident in the driver's automobile and did not disclose the potential conflicts of interest to the clients. So don't do it. Don't do it, okay? This is from the 4th Department, matter of Lazaro. Discipline, in another case, disciplinary rule 5.105A requires attorneys to decline employment where the case would likely involve the lawyer representing a different interest. You have to, that's the old rule. The new rule is what I read to you earlier. Be very careful about this, folks, because I have seen attorneys work years on a case only to have the judge say, hey, I've got to disqualify you. You can't represent both interests. How am I supposed to know what happened and how you got to this number? So I think in a lot of those cases, it can be resolved, but you have to have a separate guardian ad litem. Ask the court to have a guardian ad litem early. And if that guardian ad litem will allow you to continue to represent both interests and report to the court, I think you're fine. But just to wait till the end of the case to wait for a potential explosion is dangerous. So. Okay, so with that on that uplifting note, be careful when you're representing a client with diminished capacity. Okay, this is another problem area that occurs, and when a lawyer reasonably believes that the client has diminished capacity, you have to take special steps, and by that I mean you probably need to make sure that a guardian is appointed. For the person, a guardian, like an Article 81 guardian, has to be appointed. Why? So you have a classic case where an accident occurs and your potential client is in the hospital with a traumatic brain injury. They really can't sign anything. Let's assume that they're 25, 30 years old. They're competent, they're an adult, but they can't communicate with you, or they have been discharged from the hospital and they have continued traumatic brain injury that prevents them from going forward. In many of those cases, the attorney will work with a parent or next of kin who come into the hospital, sign the case up, and get going on the case. And this next case shows you the unfortunate consequences of taking that all the way to the end. In fact, where the Article 81 guardianship authorized the ability to go forward on the case, but in this particular case, this matter of Christopher A., which is slide 11 here. Let me just move this for a minute here. Here, the guardian executed the retainer on August 20th of 2014. Great, we have a guardian appointed. The guardian executed. Prior to commencement of this proceeding in October of 2014. Great. And her appointment as guardian on February 4th, 2015. Not good, okay? Not good, because the guardian wasn't appointed until February of 2015. There's no indication on the record that the guardian possessed actual or apparent authority to execute the retainer on the IP's behalf. Accordingly, we agree with the Supreme Court's determination, in effect denying that branch to approve attorney's fees in the amount of $335,133. This is from 2020, folks. This is not archaic. This is last year, and this is the appellate division. Not a good day. Someone just lost $250,000 in fees because they didn't have the appointment of the guardian before the retainer was assigned. And I think this case can be devastating, and we all know what happens in that moment. I've been there as an attorney. Someone's been injured. Go right to work, get the process started, but always afraid that you're going to lose the case to someone else. So let's get that retainer agreement signed. Can't do it, folks. Get the appointment of the guardian first, and then, or seek retroactive approval, nunc-pro-tunc. I guess you could probably try that and get a new retainer signed at that point in time. But please don't wait till the end of the case, because bad things can happen. The case I skipped over was another case where this is a case where and I see this as well on a regular basis, where the there's an infant being represented or an incompetent being represented, and the parent or the person who's next of kin is saying, look, I've got to get some money to take care of this person. I'm starving here, and I'm spending all of my days all day long trying to take care of my child or my brother who's been injured. And so the attorney obviously cannot lend money to the client, and the attorney wants to preserve the relationship with the client, and so they secure a funding loan for the client. Okay, not for the client, and for that person who is next of kin. And so here the court says, this is a case, this is SD versus St. Luke's Cornwall Hospital from 2019, Orange County Supreme Court. The proposed infant compromise order seeks authorization to pay from the infant's portion of the net proceeds a sum of $5,580 to Cardinal, a loan company, an advance obtained by Ms. Trellis. The request is denied, and there was a lot of bad things going on in this case, and that may have been the reason for this ultimate result. But simply put, the court says, simply put, brain injured children should not be treated by their lawyers as cash cows to be milked with excessive, unwarranted, and undisclosed fees. Hence, the request for reimbursement of an assumption of risk charges asserted by Cardinal is denied, and the financing agreement is voided as to those charges. Ms. Trellis lacked authority, absent court approval, to pledge such exorbitant percentage of any recovery away. So if you're going to do that, there are certainly cases, we all know this, where parents are in that suffering position where they're dedicating their time and they're losing money and they need money to keep the child happy at home or to keep their brother happy at home and to keep them alive. And in those situations, I think it's imperative to either get court approval, certainly get appointment if as a guardian, get court approval in the guardianship papers to be able to find some way to finance that, or certainly to be able to seek reimbursement for your out-of-pocket expenses at the end. I've never seen a judge deny reasonable expenses incurred by a parent who has been taking care of a child as reimbursement at the end of the case. So be careful on those situations. Competence. Well, the previous speakers talked about competence. The judges talked about competence. You really shouldn't get into a case, in parts of a case. I don't need to tell anybody this. I'm not lecturing anybody, but you don't need to get into parts of a case unless you know what you're doing. And that, in the settlement of a personal injury case, I'm really talking about prejudicing the client at the conclusion of the case. And that's really what my seminar is all about. And I want to talk about this Christina Grillo in 1982. She was injured in a hospital in Texas. There was a life care plan prepared in the case, in the litigation, and pegged her cost of care over the lifetime for $20 million. And during the pendency of the medical malpractice lawsuit against the physicians, the case the case turned into a settlement. And the settlement, there was a proposed structured settlement that would have paid a lot of money over the time of the child's life. And the plaintiff's attorney simply declined, didn't talk to the parent, didn't talk to the guardian. I'm sorry, the guardian was aware, but didn't talk to the parent, and there wasn't an open discussion about the potential of a structured settlement protecting the child's interest. Well, as quickly happened, the money ran out in a few short years. When the family found out that there was a potential for a structured settlement, they sued the attorney and the guardian ad litem, and a result occurred that was twice the amount of the original settlement, which allowed for a lot of it to be structured. Again, the point here is what I'm seeing, what I have seen in a lot of cases is people not even discussing the issue of the potential for a structured settlement with their client. And I think that's a bad idea. I think there are a number of issues that have to be discussed with a client, even if it's a small case. And maybe it's not appropriate to structure it all, but you've got to be able to talk to the client because these benefits, I'm going to number them, there are probably 10 of them, are not available elsewhere. So the payments are always state and federal tax exempt. They are really one of the only benefits in financial products where you can, guarantee that the client will not outlive the benefit. In other words, that money's going to be coming in every month for the rest of their lives, et cetera, et cetera. Many annuity products do that, but these do it in a tax-free, tax-exempt manner. It's the only financial product that uses rated ages. In other words, if you have a client who is 30 years old physically, naturally, but has suffered a number of injuries that are putting them at risk of surviving to their natural life expectancy, we in this industry can secure something called rated ages. And I'll show you an example of that in another illustration later. But that person, given their injuries, might be treated as a 45-year-old or a 50-year-old. So what happens is the life insurance companies will take the numbers that they would normally pay for someone who was going to live 50 years old, given her 50 more years, given her age of 30, and they'll treat her as if she's 45 and spread those monies condense the monies that they would have otherwise paid, giving her more money a month. And if they do live to their natural life expectancy of 80, that's the risk they take. If they live beyond that, the client continues to get that increased pay throughout their life expectancy, as long as they're alive. So this is something that most people don't know. Number 4 here, structured settlements provide protection from dissipation and the claims of creditors. This is a case, there are actually, quite frankly, there are a number of cases where it's probably hard for you to believe, but many people who settle cases will take their cash portion and invest in a business that they know nothing about because they've got a friend who tells them, look, I'll do the work. You just provide the money. This business will be a tremendous success. This is a great opportunity. Let's do it. So they do it. The business collapses in 2 years. And all of a sudden, not only did the partner run away, but all this debt is saddled upon the person who is receiving, who had the settlement and who is also receiving or maybe receiving a structured settlement. And so when they filed bankruptcy, the trustee said, I want that structured settlement money as well. I want that to be paid, used to be paid toward the debts. And the courts have consistently said that structured settlements are exempt from the trustee's breaches in bankruptcy. So that's a particularly important thing with clients, given the fact that some of them are unsophisticated and many people are very trusting and invite others into their lives who've got great plans for the client's money. And their structured settlements, and this is important, particularly since 2014. There are 2 types of Medicaid now. There's the type of Medicaid for someone who's disabled, and then there's the Affordable Care Act version of Medicaid, which the vast majority of Medicaid recipients are on today. So, and that is based not on assets, but based on income. And income at 133% of the federal poverty level is the threshold that has to be reached before someone is now putting their Medicaid eligibility at risk. So if you're a single individual and you make less than $15,000, you're going to get Medicaid for free. If you have structured settlement income coming in for $25,000 or $24,000 a year, $2,000 a month, it does not count toward that eligibility test. It's important to know it's exempt, it's not income. You take that same amount of money that you use to fund the structured settlement payment and you put it into an investment that generates $2,000 a month. And what do you have? You have income above the poverty level that is going to disqualify you. In fact, even if that income, that payment stream is coming from tax exempt bonds, federal and municipal bonds. If they're tax exempt bonds, they are part of the modified adjusted gross income, MAGI, that's what it stands for. And therefore they get added back in for purposes of the calculation. And you might lose the incredible benefit of free healthcare. So structured settlements are important. These are the things that, and I'll explain how we deal with this later. You know, there's no trustees commissions. It's a one and done. When the structured settlement is set up, the monies keep coming in. So oftentimes there'll be a situation where $500,000 is in the trust and $500,000 is funding in the structured settlement. The structured settlement amount will pay into the trust on an annual basis or a monthly basis. But the corpus that was used to purchase the structured settlement is not subject to the trustees commissions or the management fees for the monies that are in the trust. So that's a significant savings. The other final thing, well, there's a few more, but this is also important. If you have someone who's of advanced age, or you need to think about this particularly, when you designate a beneficiary in a structured settlement, when that person passes away, it goes directly by contract to the heir that is designated, the beneficiary that's designated in contract. So someone who might otherwise be subject to, let's say someone was 65 years old, had structured settlement payment streams coming in, and at the age of 70, developed dementia, went into the nursing home and incurred a huge bill upon their death. That money from the structured settlement, if it was guaranteed for 30 years, will pass directly to the beneficiaries without being subject to the Medicaid estate recovery. So these are benefits that you can use for also, we can skip over some of these, but again, a college plan, a lot of times people use it for a guaranteed college plan for their children. If their children are getting the proceeds, it's frequently done, but even a parent who is getting some money, who wants to make sure, and we find a lot of times in the discussion with the client who's settling the case, that their main concern is like getting a house, being secure, and then making sure their kids' college education is taken care of. And how you do it with a structured settlement that pays at the times that your children will be going to college. If the child doesn't go to college, parent gets to keep the money. It's not put in the child's name. It's not being used to disqualify for the child from financial aid because it's still in the parent's name. So there are a number of other reasons that have to be addressed. And I think there's another rule that comes in, and I think it's Rule 2.1 of the Rules of Professional Conduct. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering the advice, the lawyer may refer not only to the law, but other considerations such as moral, economic, social, psychological, and political factors that may be relevant. And why I say this and why it's important is because frequently we have attorneys who, you know, have great 401k plans, have enjoyed the benefits of the past 10 years of meteoric growth in the market, and they're saying, you know, I'm not even going to tell my client about a structured settlement. The rates are different. They can, as one attorney told me, you know, I could throw a dart and get 7% in this market. So I'm not even going to discuss it with my client. You don't know the client mentality. There are people out there who have investments in the stock market who you would think are very aggressive, but have 20% in the stable value fund, which means essentially they're getting zero because they have some protection. You need to understand that being secure, you need to consider that it might be your client's desire to be secure, and that might outweigh the desire to think that your client, who was a laborer, is going to become an investment guru and put money in the stock market. Balance is key. Keep those things in mind. Think about your client's best interests. And so the thing that you need to do is create a Grillo waiver. If you talk to your client about it, you bring it up and they have no interest in it at all, then the case that we talked about earlier, the young lady whose Guardian did not elect to structure the settlement. We've created a waiver based on that case, the Grillo waiver, and just document in writing that the benefits of a structured settlement were explained, that the dissipation and the investment risks of cash settlements were explained, the tax consequences were explained, the potential loss of public benefits like Medicaid were explained, and the decision not to structure is irrevocable. Referrals for competent tax advice were offered. Just do that. Make it a policy to have a checklist in every case to protect yourself. Okay, so there's another case that I didn't get to. It's in your materials. It was a case called Lyons, and in that Lyons case, there was a case where a defendant offered a number of policy amounts, the settlement of a case for an infant child. The plaintiff's attorney and the plaintiff's parents assumed that the amount that was going to be paid for the rest of the child's life, I believe it was $2,000 a month for the rest of the child's life, was based on a legitimate annuity proposal that they looked at. The annuity proposal was presented by the defendant, and the parents were told the case was worth essentially $975,000, the value of the settlement, and that the cost of the structure was like $660,000. And lo and behold, the clients later received some paperwork that indicated that the child had one of those rated ages that we talked about earlier, that the child was treated as if they were something like 60 years old. And therefore, the defendants, instead of using that rated age to buy more benefits for the plaintiff, did the opposite. They used it to reduce the cost of the benefit that they had illustrated to the plaintiff, and kept a savings of $260,000. Somehow the plaintiffs later found out, and then sued the defendants for fraud, and sued also the plaintiff's counsel who represented them for malpractice. In that case, the court determined that the defendant and the defendant's agents have no legitimate ethical responsibility to the plaintiffs unless there was actual fraud, unless there was an actual representation in writing that this is the amount of money that we're using to fund the structure. So the key there is to make sure that you always have, and your clients always have, their own representative in that transaction. So next, we talk about, I want to talk about the fact that in liens, this is a area of great trouble. This is what the courts think. Folks will wait till the end of the case to address liens for some reason. It continues to happen. It's problematic. It puts everybody in a difficult situation. I can't tell you how many times a week we get the phone call that says, "Hey, Paul, I had a number. I thought the lien was going to be, $6,000, and it was a $25,000 policy. I settled the policy. I settled the case, and turns out the lien is $100,000. What do I do?" More frequently, we have a case where there's a $500,000 settlement, and the client thinks that they're going to get $300,000 or thereabouts, and they have a Medicare lien that is $12,000, $13,000, and they haven't had it updated frequently. And it turns out after they settle the case, that Medicare lien is over $100,000. That happens frequently. Whether it's through failure to follow up, or just ignorance, but it happens. And when that happens, you got a problem, right? You got a client who thought they were going to get $300,000, and now the client's going to get $200,000. It's a bad day for the attorney, and it requires a lot of fixing and delay while things are trying to get fixed. Sometimes they don't get fixed. The vast majority of times things can be done, but don't put yourself in that position. Remember what the judge said about competence. That applies to all aspects of the litigation. So in a case where there are liens, you have to remember also that you can't simply ignore the claims of a creditor. You have to address them. Now, there's certain rules, and we're going to go through some of them relative to ethics and the handling of a lien. But just remember this. This is an excerpt from Chief Justice Roberts' what just happened here? In the case of Montanil, 2015 case, and this was a case where the attorney tried to work out the lien with an ERISA, self-funded ERISA plan. He kept telling him, "Look, if you don't make me a deal, I'm going to send the money to the client. I'm going to send the money to the client. I'm going to send the money to the client." Lo and behold, they didn't get back to him. They just wanted to squeeze him, and he sent the money to the client. The client wasn't much money, so the client quickly dissipated it. And there's a rule in ERISA that says there must be a fund to recover from. There can't be an equitable lien if there's no fund to recover that money from. And here, the fund had been evaporated by dissipation. And this is what the court thinks of the lawyer who sent that out. And this is Justice Roberts said. So the beneficiary, even the beneficiary's counsel gets a letter saying, "By the way, we have a lien on this. Good luck. I hope you recover a fair amount. But if you do, make sure you put it in a separate account." Again, setting up that separate account. "Make sure you notify us." And then the judge says, "And if that beneficiary or the lawyer just ignores that, that's not a basis for fraud?" Well, the case turned out that because that fund had been evaporated, there was no recovery, but there was no recovery for the fund. But we are saddled with different rules here in New York. Funds belonging in part, this is the Rules of Professional Conduct 1.15. Funds belonging in part to a client or third person, in part belonging to a lawyer or law firm, shall be kept in a special separate account. And if there's a dispute as to who has access to those funds or who's entitled to the funds, the disputed portion shall not be withdrawn until the dispute is finally resolved. More importantly, you're required to notify a client or third person of the receipt of funds securities that, in other words, the other person may have an interest, okay? And the comments to Rule Section 1.15 are also important. So this is where we see, and this is where we see trouble on many occasions, okay? Comment 4 recognizes that third parties may have lawful claims against specific funds or other properties in a lawyer's custody, such as a client's creditor who has a lien on funds recovered in personal injury action. The lawyer may have a duty under applicable law to protect such claims against wrongful interference by the clients. Now, this is the key, and it's a little bit of a window here. In such cases where the third party claim is not frivolous under applicable law, the lawyer must refuse to surrender the property to the client until the claims are resolved. This is the hardest part, of this situation. The hardest part is when your client is calling the attorney saying, "Hey, I don't care about Medicaid. I don't care about Medicare. I want my money. I want it now." And and you're in a position where you're trying to keep the client happy, source of referrals, and you say, I really haven't heard back. I tried a couple times. I'm just going to send them the money. I'm going to send her the money. Be careful about that. Be careful about that, because our rules say, and our commentary to Rule 1.15 says, "The lawyer shall not unilaterally assume to arbitrate a dispute between a client and the third party, but when there are substantial grounds for dispute as to the person entitled to the funds, the lawyer may file an action to have the court resolve the dispute." Okay, so there's an opportunity. But let's go back. There are situations where, remember the kicker, the trigger here is when the claim is not frivolous under applicable law. So in New York, insurance companies who have received a premium in exchange for payment of medical expenses are not entitled to recover those expenses under our General Obligations Law 5-335. So if you know that it's an insured policy, not a self-funded ERISA plan, but an insured policy, such as like a Blue Cross Blue Shield that had received payment and they're trying to get recovery, then I think you're okay. But better to have this resolved than have it blow up. There are cases out there, and they're too numerous to mention, where attorneys have been sued for double damages for the failure to pay Medicare back, worse, for the failure to pay a Medicare Advantage plan back. Many cases out there where attorneys have been sued, and courts have granted summary judgments against the attorneys for failure to satisfy a Medicare Advantage plan lien. So we really don't want to just ignore this. Get some help, or get to know the law, be competent in that area. The final message from this is that many of these disputes can be resolved in a favorable fashion if the right folks are brought in time. You're able to delegate some of this responsibility. You're able to. There are rules out there that allow you to. Well, this is another. I'm sorry. This is another follow-up to that rule 1.15. It's again telling you the ethics opinion says that you ought to hold the money until it's resolved. File an interpleader. This is an interesting case I bring this up because it still happens, believe it or not. This is a case from 1996, but this is where the lawyer dispersed the entire amount, didn't pay Kaiser Foundation back, and the lawyer was found to be responsible for the full amount of the lien. So, so you have to balance the Montanil rule determined by the Supreme Court, where if the monies are dissipated, your client walks free, doesn't pay anything back, and your obligation under the disciplinary rules. That's the difficult thing. There's a recent case. This is a bad case. This is a recent case from 2020 in the Southern District of New York, where the court granted 100% recovery of the $25,000 limits of coverage to the union plan, and the court rejected the common fund doctrine and basically said that, look, the plan takes priority. Remember what I just said about Judge Roberts a little earlier? Most courts think that there's an automatic entitlement. Look, those people paid, you got money, we have to give that money back to them. That's in the contract. There are exceptions to that contract, but this is the default posture of the courts, is to try to find a way to get that money back. Have I lost video?
You did for a moment there, but you're back now. So go ahead.
Okay. Am I? Finally, there are ethical rules permitting you to outsource lien resolution services so that you don't have this problem. Numerous ethical rules that allow for this to happen. New York City Law Association Ethics Opinion 739 allows for fees for specialized counsel to retain, to be retained to negotiate a private lien. There are a number of ABA rules that allow this as well. So you can do that, and it's a legitimately expense in certain circumstances to be charged to your client. We also believe that we've retained our own counsel and believe that that's really a charge that should be allocated to the plaintiff's share of the settlement if you do refer out to a third party to handle the lien. Finally, there's a case here where an attorney violated the rules by unilaterally attempting to negotiate a Medicare lien. The case had, he had already taken settlement of a fee of $137,000 on the case. There was about $97,000 in a Medicare lien, and the attorney decided that he would negotiate the lien. Medicare agreed to accept $60,000 in lieu of their full $97,000 claim, which of course would have been reduced by the cost of litigation anyway to something like $63,000 or $64,000. Then the attorney took an additional legal fee on the $30,000 of $30,000 from that amount that he was holding in escrow. And unfortunately for him, and this was a long fought out battle, the court found him in a violation of a number of disciplinary rules, including misappropriating funds, and they confirmed the arbitrator's decision, the referee's decision, but they did not. They merely sanctioned him. I'm sorry, bouncing around here. Sorry about that, Judge. Merely sanctioned him because he had an outstanding, stellar reputation and had no previous violations. So, having said all that, I think we're at the conclusion of my presentation, and any questions, anyone?
I think, are we going to wait until the very end to do the question? Yeah.
Yeah,
okay.
we'll get to Q&A at
Yeah.
the end.
Okay.
Well, thank you very much, Paul. My name is Alexander Villardo, and I am Adelina's co-chair on the Educational Committee.
I'm sorry, any
Before
questions?
our second course code is settlements. That will be in the chat as well. And our next speaker is Vincent Doyle, a partner at Connors LLP. Vince is widely respected throughout the state as a commercial litigator whose practice includes civil and white-collar criminal litigation and representation of professionals in disciplinary proceedings. He also regularly advises clients on legal ethics matters. He has held a number of leadership positions within the state and local bar associations and has served on numerous government and independent panels seeking to improve the legal system. Most prominently, Vince has served as the 114th president of the New York State Bar Association. Vince served on the board of directors of the Bar Association of Erie County and also serves on the panel that screens applicants for judicial appointments by New York's governor. He's an adjunct instructor at UB School of Law.
Are you able to hear me?
Vince is a past recipient of the Lawyer of the Year Award from the Bar Association of Erie County and also received a Distinguished Alumni Award from UB Law. So now I will turn it over to Vince.
Are you
Vince,
able to hear me?
you're on mute.
Thank you very much, Alexander, for that nice introduction. And I want to thank the organizers of this event. It's a terrific group of speakers, and I've learned a lot already. I'm looking forward to the rest of it. I'm amazed to see so many of you taking 4 hours out of your Friday to learn about legal ethics. And I assume all of that is very altruistic and has nothing to do with the mandatory CLE requirement of 4 hours of ethics training every 2 years. But in any event, I was asked to speak on the topic of representation before the grievance committee and what the grievance committee process, the disciplinary process, is like. That's a scary topic. Even I admit that. I find that I'm not often asked to speak about that specifically, but I think it's a good thing. I've done this work for 20, 25 years now, and I'll tell you, I'm still scared by the process. In particular, every time I represent a number of attorneys, and I often get correspondence from the grievance committee counsel, and every time it comes in the envelope, it's labeled personal and confidential. My secretary won't open it. She just puts it in my mailbox, and I'm scared to open it because I'm thinking one of these days it's going to be a letter for me. Luckily, it hasn't been yet, but it is a scary process. Attorneys are scared of it, but I think it's a process all lawyers should learn about and know about. It'll help demystify the process. There's a good chance that someday yourself or someone you practice with, a friend of yours, will receive a complaint. So you should know how they're handled. knowing how the system works in many ways can help you avoid complaints or help head them off before they happen. And there are some of you present here who may be interested in doing this type of work, representing lawyers who receive a grievance complaint. In fact, looking through the people on the screen, I can see that there are some of you who do this work. I can see there are some people who are now on or have been on grievance committees, and I also see at least one grievance committee counsel on. So I'll try to be accurate in everything I say. Let's talk a little bit about the process and what some of the rules are. I'm going to share my screen. There it is. Okay, first of all, an overview of some of the laws that are involved. And we start with the purpose of the attorney disciplinary process. The courts have often spoken about this. Fourth Department Court of Appeals have repeatedly said that the primary purpose of the attorney disciplinary process is the protection of the public. That helps to understand why the process and why the courts view certain things as seriously as they do, like violations of the rules regarding attorney trust accounts, and any allegation that clients have been misinformed by the attorney are taken extremely seriously, because that is the primary purpose of the attorney discipline process. What it's not supposed to be about is punishment. Now, I say not supposed to be about. You will find that quote in many, many cases that come out, that the purpose of attorney discipline is not to punish the attorney. There are other means of doing that. There are legal malpractice lawsuits, there are criminal cases, and often attorneys that I've represented are subject to one or both of those. And we're going through the discipline process, and I'll remind the committee, I'll remind the court that this is not about punishment. That at least is not supposed to be about punishment. The legal authority that the disciplinary process uses, first of all, we start with Judiciary Law, Section 90. That's why the courts, Judiciary Law Section 90 is a section that gives the courts the authority over attorney admissions and attorney discipline. It's not like that in every state. If we go back a long time in New York, it wasn't like that. Attorney discipline was handled by the State Bar Association. It still is in many states that have what are referred to as mandatory bars or unified bars. But we don't have that in New York. Membership in the State Bar Association is voluntary. But in New York, the decision was made to rest the authority to discipline attorneys in the court system. And the Section 90 vests that authority in the appellate divisions. So each of the 4 appellate divisions have created their own system, their own grievance committee or committees to handle the complaints. The other relevant portion of Judiciary Law Section 90 you should know about is Subdivision 10, which provides very strong confidentiality provision. All attorney complaints, everything about the disciplinary process is confidential and may not be revealed until and unless the appellate division determines that some public discipline is appropriate. So the fact that a complaint has been filed or anything that happens to it, including dismissal or anything short of public discipline by the appellate division or an order from the appellate division, may not be revealed. And we see that occasionally come up, for example, in a very hard-fought litigation. One side may file an attorney grievance against the other side's lawyer. And then you see that referred to in motion papers to the judge in that underlying case. That's not appropriate. Those things should not be discussed. They are confidential under Judiciary Law Section 90, Sub 10. With that background, what I like to refer to as a substantive law, in other words, what are the ethical rules or the rules that are enforced by the disciplinary system? Well, primarily they are the rules of professional conduct, which we'll refer to as the rules with a capital R for this presentation. they and I want to explain the process for where the rules of professional conduct come from, because I think it's relevant to some of the things we're going to talk about here. The rules are issued by the 4 appellate divisions jointly. The 4 PJs, presiding justices of the appellate divisions, get together and they decide what the rules of professional conduct are going to be and whether there's going to be any modification to them, amendment, any new rules, anything like that. Normally, the rules are voted on by the 4 appellate division presiding justices based on suggestions that come from the New York State Bar Association. The State Bar has a committee, has the unusual acronym COSAC. It's the Committee on Standards of Attorney Conduct. And COSAC will draft rules and modifications, amendments. They go to the State Bar Association's House of Delegates where they're voted on. And if they're approved, they're then sent to the appellate divisions for consideration. And most usually the appellate divisions pass them, but there are times where they modify them or they reject suggestions that have been made by the State Bar. But the rules themselves are the black letter law. They are the mandatory provisions of the rules of professional conduct, what an attorney shall do or shall not do. Those come in the rules. There are other sources that you should be familiar with. One is the comments. The comments are explanatory notes that follow the rules. And if you get a set of the rules, make sure it has the comments in it. The comments come from the State Bar. They are written again by COSAC and then passed by the State Bar House of Delegates. The comments are not the black letter. They are not mandatory. They are not the rules that we must follow, but they explain the rules. And they're often cited by the grievance committees, by the appellate divisions, by the courts when they're trying to interpret what the rules mean. So they're very useful in any analysis of what the rules mean. And then we have ethics opinions, and we've already heard, and I know Paul Isaac cited a couple ethics opinions, so we've already heard about them. What are ethics opinions? Well, I shouldn't say every, most bar associations, including the State Bar, including the bar associations in New York City, they have a city bar, and they also have a New York County lawyers bar, and the Erie County bar for that matter, have professional ethics committees that will receive and answer ethics questions from lawyers. And there are certain requirements they have about what the questions can be. But in any event, they issue written opinions that interpret what the rules are and apply them to specific factual situations that the lawyers have asked about. They, again, are very useful when you're trying to understand or interpret what the rules mean and apply them to certain factual situations. I have cited them many times in disciplinary matters, and the courts have found them persuasive. Oh, sorry, before I get there, the last thing I wanted to mention, it's not on the slide, but there are also, various resources out there, books, long articles interpreting what the rules mean. If you have an issue that you seriously need to do some research on the ethics rules, or you want to get into this type of representation, I would recommend that you get a book called Simon, S-I-M-O-N, New York Rules of Professional Conduct. It's Professor Roy Simon, who's probably the preeminent expert on the New York Rules of Professional Conduct. He has a very, very lengthy book where he takes each rule, breaks it down almost word by word, explains what it means, and has case sites, ethics opinion sites, and other materials that are very helpful. Okay, so moving on in terms of legal authority, if the rules of professional conduct are the substantive law in this area, the procedural law is found in the rules for attorney disciplinary matters. And those are part of the court rules that are found in 22 NYCRR. They are joint rules of the 4 appellate divisions. We'll talk about that in a second, how that came to be. But they provide all the procedural rules about how disciplinary matters are handled. Okay, so proceedings before the grievance committee. And let's talk about the grievance committee itself for a second. As I mentioned, in each appellate division, they have their own grievance committee or committees. I'll talk about the 4th department because that's where we are now. There are 3 grievance committees for the 4th Department, one in each of the 3 judicial districts that are covered by the 4th Department. So there's one in Syracuse, which is the 5th district. There's a grievance committee centered in Rochester, which is the 7th district. And here in Buffalo, we have a grievance committee for the 8th judicial district. All of them are about the same size. Specifically in the 8th district, there are 21 members. All members of the grievance committee, by the way, the committee members are volunteers. They are practicing lawyers. 3 of them are non-lawyers. That's by rule. So 3 non-lawyers, 18 lawyers, all of whom are volunteers. They're not paid members of the committee. So those are the committee members. In addition to the committee members, there are staffs. Each grievance committee office has its own staff. In Buffalo, there is a grievance 8th district committee. They have attorneys who act as counsel to the grievance committee, and they have investigators as well. Just to give you some stats, I'm going to talk a little bit. Well, let me do the stats after. So what's the process? The process begins when, someone, usually a client, but not always a client, makes a complaint, a written complaint to the grievance committee. I say it's usually a client, but it can be anyone. It can be the client on the other side. It can be an attorney on the other side, or an attorney in the community. It can be a judge, for that matter. In addition, complaints can be sua sponte, meaning that the grievance committee itself is bringing a complaint, starting a matter. Sometimes they read about things that happen in the newspaper, or hear about them from some other source, and they sua sponte start an investigation. So a complaint comes in, and basically there's an intake process. Every complaint that the grievance committee receives, it has to examine. Now, the examination originally, or in the first instance, is undertaken by the staff, by the attorneys and the investigators. If they can, there's some things they can do without it going any further. There is a process where they can dismiss the complaint. They can essentially reject the complaint. If they review the written complaint and determine it does not raise an issue of legal ethics, or an issue under the rules of conduct, then they can simply dismiss it, and they'll advise the complainant of that. This happens, for example, if they receive something that says, I had a lawyer, we lost the trial, I think my lawyer did a bad job. Ordinarily, that's not an ethics issue. I mean, it may rise to the level if there are really allegations that the lawyer was incompetent, but simply a complaint that my lawyer didn't get me as much money as I wanted, something like that isn't going to go any further. If the complaint is, my lawyer is a Martian and sending radio waves to my brain, again, that's something that the staff would reject as not being a complaint. Referral, there are procedures, including in Erie County. The Erie County Bar Association has a grievance process that is meant to address more minor complaints, usually complaints about fees. A complaint comes in that, my lawyer charged me X amount, and then I pled guilty and he didn't give me any money back, or she didn't give me any money back. Those are the types of minor disputes that the grievance council staff might refer to the Bar Association of Erie County process to deal with. So fee disputes or minor complaints. If it's not dismissed or referred, if it is interpreted as alleging a real, serious, possible ethics issue, then the grievance committee will undertake an investigation. Again, that is undertaken by the staff. The first step in the investigation is almost always sending the complaint letter to the lawyer, who is referred to as the respondent here, the respondent attorney, the subject of the complaint, with a request that the respondent provide a response to the complaint. Now, I'm going to stop here in the process for a second. This is one of the most important steps in the entire process. Obviously, you hope that a complaint is never filed against you, but if it is and it's sent to you by the grievance committee, the response that you file to the grievance committee is a tremendously important step in the process. It's a chance to address the complaint, to convince staff or the committee that there's no merit to it, that it should be dismissed outright, and that there should be no further investigation, all which is a great thing. But there are huge pitfalls to it. As I mentioned, it is a tremendously important step in the process. Your response will be sent to the complainant, who is then asked to reply to it. So the content and the tone of the response is very, very important. It's a problem if the response further inflames the anger of the complainant. And it's very common for lawyers who respond on their own, respond either defensively or angrily with attacks against the client. So if it further enrages the complainant and encourages him or her to make more complaints, that's a problem. It's also a problem if there's anything in the response that can be disproven or contested by the complainant. That is a big problem. If you have said something that is later found out to be incorrect in your statement, the grievance committee can add that, consider that as an additional act of misconduct. In addition to whatever the complaint was about, you have now made a false statement in your response, and that can result in worse problems. So poorly worded attorney response can exacerbate whatever problems you may be facing. And we'll get later to my advice about getting counsel in these situations. We'll come to that later in the presentation. In addition to asking the attorney for a response, the investigation can include other steps. Counsel or staff can ask for records, materials from the respondent attorney. They can request bank records, copies of checks, trust account records. They can ask for the entire client file, and often do, records of communications. And the respondent attorney is under an obligation to cooperate with the investigation, must provide all of the material that is requested. Failure to cooperate is considered conduct prejudicial to the administration of justice and is itself misconduct under the rules under 8.4D. So all of that material can be collected by the committee, by staff on behalf of the committee. They also have the authority to subpoena records. So they can subpoena bank records, they can subpoena other records, they can get records from courts, from other attorneys. They often make requests to attorneys on the other side if it's a matter in litigation. So they have pretty broad authority. They also have the authority to ask the respondent attorney to come in for an interview, sometimes on the record, under oath, sometimes informally. They can do that with other witnesses as well. So after the investigation stage, then we talk about the disposition stage. And I'm just going to put these up. These are all different types of dispositions that can be done at the committee level. Some of them, in fact, including the dismissal, as I mentioned, can be handled by the committee's counsel on its own without going to the committee. But the most of the rest of them are things that the committee can do. I mentioned diversion application. There is and we'll talk about this when we talk about the rules, but there is a provision in the rules that allows a matter under investigation to be diverted to what's referred to as a monitoring program. And that is where an attorney has a substance abuse, alcohol, substance abuse, mental health issue that is impacting them and played some role in the misconduct. And the application is to allow the attorney to enter a monitoring program where they receive treatment, where their practice is monitored by someone who they check in regularly with, and the investigation is put on hold while the attorney enters this program, hopefully gets healthier as a result of that, and then you come back to the investigation and somehow it's determined what's going to happen. Other types of dispositions. A written admonishment is a possibility that used to be referred to as a letter of advisement. So written admonishment is a type of discipline, but it is private. So in other words, it's not announced in the newspaper that Attorney Doyle received a written admonishment, but it is considered a disciplinary resolution. Letter of advisement, which used to be called a letter of caution, is not discipline. It's also private, so it's not disclosed that the lawyer received that, but that is another type of disposition that the committee can do. And then finally, we have file charges. We'll talk a little bit about the process here. If the committee counsel believes that the committee should authorize charges, they will prepare a written report to the committee and make that recommendation to the committee. The respondent attorney is allowed to respond to that. So this is a different document. I'm not talking about the original complaint. This is now staff counsel's report goes to the committee, and the respondent attorney is allowed to file a response to staff counsel's report. Those two things are reviewed by the committee members, and then on a day that is selected for committee meetings, the committee will offer the attorney respondent the chance to appear, with or without counsel, and make their arguments about whether charges should be filed. If the attorney doesn't have to appear, but has the option to appear. After the matter is considered and both sides are heard from, the committee then votes. And if the committee believes that there is probable cause to believe that misconduct occurred and the attorney committed that misconduct, they can authorize the filing of charges. How does that happen? Charges are handled at the appellate division. They're started by the filing of a petition. That's what I refer to as filing the charges. Petition is prepared by staff counsel at the direction of the committee. It's then approved and signed. And it serves the same purpose as an indictment in a criminal case or a complaint in a civil matter. It's a document that it's supposed to have specific allegations, paragraph by paragraph, about the conduct engaged in and how that constitutes misconduct and what rules were violated. That's filed, served on the respondent attorney, who then has to file an answer. Again, just like a civil case, criminal cases, you don't have to file answers, but in civil cases, you do. You have to answer each of the allegations in the complaint. If any of the allegations are denied, or what lawyers call DKI, denied knowledge and information, then the appellate division will normally order a hearing, which is conducted before a referee appointed by the appellate division. The referees are usually retired judges, though not always, but in my experience, they're almost always retired judges. Now, in many cases of disciplinary cases, the facts really aren't in dispute. What's in dispute may be whether those facts constitute misconduct, or more usually, whether those facts and that misconduct justify discipline, and what level of discipline do they justify. If you have a case where the facts aren't really in dispute, you often will, as lawyer for the respondent, get together with staff counsel for the committee and reach a stipulation on all of the facts. If that happens, then you usually don't have a hearing. You simply go back to the court, the appellate division, where the court, now, if you've had a hearing, the referee will issue a report finding facts and making recommendations as to whether the rules of conduct have been violated. But ultimately speaking, it's the court, the fourth department, in our case in Western New York, has the ultimate authority to determine whether the attorney has been proven to have violated any of the rules of conduct and what the appropriate discipline is. The court has all of the options that we already discussed regarding what the committee could do, and some additional options. So in other words, the fourth department can dismiss if it finds that the charges have not been proven. It can order the issuance of an advisement, a caution. It can order the issuance of an admonition. And as I mentioned, an admonition is discipline, but it's private. The next level is a censure. Censure is a public discipline. And it's what it sounds like. It's a public condemnation of the attorney's conduct. It's a censuring of the attorney's conduct in the decision issued by the appellate division. The two worst options are suspension of the attorney's right to practice And then finally, disbarment is the most serious of the resolutions. Now, just some stats for you, and this isn't in a sheet, but I just pulled them up because I didn't, after scaring you with all the different things that can happen, I want to tell you what the chances are, or at least statistically, how often these things happen. So in the fourth department, there are approximately 14 to 15,000 attorneys that are in the fourth department. Each year, the grievance committee issues a report that goes over the numbers of how many cases it had and how they were resolved. The latest one that's on their website is from 2019, so I haven't seen the 2020 numbers. But the 2019 numbers indicate that there were approximately 1,800 new matters, meaning complaints, inquiries, or sua sponte investigations. So about 1,800. The committee works very efficiently. They dispose of about 1,750 matters in 2019. That's the year I'm talking about, 2019. So they disposed of almost all of the, same number as came in. Now, some matters carried over from the prior year, and some carry over into the next year or so. But in any event, they dispose of about as many matters each year as they receive. So of those 1,750 that were disposed of, about 1,200 of them were dismissed, either by the council because they just didn't make out an actual complaint, or by the committee, or by the court. So that's 67%. So we're near 70% of all complaints are dismissed with no consequences at all to the attorney, other than the anxiety of receiving a complaint. So what about the worst options, suspension or disbarment? Well, for 2019, there were 18 total, 12 suspensions, 6 disbarments. That's about 1% of all the matters that were considered. So we're talking about very low numbers there that should give you some reassurance. Excuse me. All right, so some recent developments that are relevant for you in this area. In 2016, and it carried over into 2015, it carried over to 2016. There was a commission created by the chief judge of the state on statewide attorney discipline. I was appointed to that commission. There were some other Western New Yorkers, but it was about a group of about 20 people across the state, including some judges and some grievance counsel, staff counsel, and some attorneys who work in this area. The whole thing was really moved. There was a move to reform the attorney discipline system, and the primary inspiration or mover of that was really a New York Times article that was published, written by a law professor, Professor Stephen Gillers, who is a well-known expert on legal ethics matters. His point was that the system was too opaque, it was too secret, that it should be open to the public, and specifically, he wrote that his examination of some statistics about what happens to some of these complaints showed that upstate, so including us, and Professor Gillers is a New York City law professor, that upstate, the courts were too lenient on attorneys, which is something I don't agree with, but that was what he wrote. As a result of that and some pressure that sort of built politically, the chief judge created this commission specifically to examine a couple issues, one of which was, should there, instead of letting the 4 appellate divisions create these individual grievance committees and judicial districts as we have in the 4th Department, should there be one uniform disciplinary court or entity for the whole state that would apply uniform type punishments? So that was one issue. The second issue was, should the process be more open? Should the confidentiality that is guaranteed by Judiciary Law Section 90 sub 10 be done away with, and the matters opened from the issuance of the complaint? If you think about it, when you file a civil complaint, that's a matter of public record. When an indictment is filed, that's a matter of public record. But when a grievance complaint is filed, or probably more appropriately, when the petition is filed by the grievance committee, That's not public. That's still confidential under the law. So the committee met several times, considered various issues, and ultimately rejected each of those two reform proposals. But what the committee did recommend was that the 4 appellate divisions, each of which had its own rules for how disciplinary matters were handled, and the grievance committees often had their own rules, that those rules be made uniform, and that there be a single set of rules that would apply in all 4 appellate divisions. Those uniform rules came out in 2016. It was a bit of a compromise rather than open the process or making a uniform, one disciplinary court. Let's have the same procedures. Now, having been part of it, in my mind, as an attorney who represents respondent attorneys in these disciplinary matters, there were some positive things that came out of these uniform rules. One was the diversion process. Now, the diversion I talked about before, which is an attorney who is suffering from drug or substance abuse, mental disorders, the discipline can be diverted while they receive treatment, attention, while they're monitored. That was something that the 4th Department was a very early opponent and adopter of. The 4th Department rules had that before any of the other departments. Some of the other departments had adopted that, but not all of them. The uniform rules adopt that basically in the manner that the 4th Department had done it. So that's something in the 4th Department we should be proud of. Discovery. There had been no uniform rules about what type of discovery would be allowed to respondent attorneys. Now, I can tell you, having done this work, that the Grievance Committee Staff Council, they're very decent people, and they informally provided anything in discovery that was needed. But now there is a rule that attorneys are entitled to ask for discovery and entitled to receive it. Now, it's not. There are some limitations. People know if you're working on a civil case or a criminal case, you have the authority as attorney for a party to subpoena records to the court. That authority does not exist under the rules for attorney discipline matters. You have to ask the court or the court's clerk for permission and ask it to issue a subpoena. Grievance counsel can subpoena things, but respondents have to ask permission. And then finally, discipline on consent. If we use the term plea bargain, we're all familiar in criminal cases. You often plea bargain, and sometimes you can bargain regarding what type of sentence will be imposed, and maybe even ask the judge to approve that. But there had been no process for any type of plea bargaining in attorney discipline matters in the 4th Department, at least before. There is now a process where if grievance counsel and the respondents counsel get together and agree on what the discipline should be, they jointly submit a motion to the court recommending, we recommend that a censure be the discipline in this case, or we recommend that a 6-month suspension be the discipline in this case. That motion can be made. It's still up to the court to decide, but the motion can be made, and that's a positive development in my view. All right, watching my time, getting through some recent developments. We talked about the rules. Now, the procedural rules. Now, I just want to make you aware of 2 recent amendments to the rules of professional conduct, and they're, it's an ever-changing document. So every year, it's possible that the 4 appellate divisions can adopt rule changes, and again, they often come from recommendation from the state bar. So one of the exceptions that came to be, and these were effective June 18th, 2020, these 2 changes I'm going to talk about. So Rule 1.8 and the change, the amendment is often referred to as the humanitarian exception. The old Rule 1.8E said that lawyers could not advance money to clients unless they were court costs and expenses of litigation. So you can pay you can pay filing fees, you can pay expert fees, advance them to the client, and then if there's a recovery, you receive that back. But that's the only money you could give to a client, the only things you could advance. The new rule Again, it's a humanitarian exception adopted as a result of the pandemic, so I don't know if it's going to be permanent, but it allows legal services organizations, okay, and that's a defined term, and pro bono attorneys, and only those groups. So it doesn't apply to you unless you're in a legal service organization or it's a pro bono case. It allows you to provide financial assistance to low-income clients beyond the costs and expenses of litigation, and those that financial assistance can include basic living expenses. So that was one of the rules adopted as a result of the pandemic. The other change that a lot of people don't know about, I've talked to a lot of people about this, is a change to Rule 7.5. Now, 7.5 is entitled Professional Notices, Letterheads, and Names, but it basically is the rule that tells you what you can name your law firm. And we're probably all familiar with the old rule that said, really, I'm paraphrasing, but the only thing you can name your law firm is some combination of names of attorneys who work at the firm or used to work at the firm that may be retired or passed away. You specifically could not use a trade name. What do we mean by trade name? Well, we mean slip and fall lawyers or personal injury lawyers as the name of the firm. That was not allowed. On the recommendation of the State Bar, and the reasons for that were that on recommendation of the State Bar, that's been changed. You can now use a trade name as the name of your law firm. You can now practice under a trade name for your law firm. Why did they change that rule? They changed it because there have been challenges across the country, and there's a pending challenge right now on First Amendment grounds that the rule restricts the attorney's First Amendment rights. In fact, if you go back over the last couple of years, many of the rules on advertising that were in the rules of professional conduct have been changed in order to avoid First Amendment challenges. So the courts have been increasingly willing to consider First Amendment challenges by lawyers. And as a result, the State Bar recommended that the court change this rule, and they have changed it. So now, specifically, lawyers are allowed to practice under trade names. Now, let me just read. I told you about the comments. I'm just going to read from 2 comments to the new rule that sort of explain them. So this is comment 10 to Rule 7.5. For example, with respect to trade names, a law firm whose practice includes real estate matters may use and practice under a name such as Abel Baker Real Estate Lawyers, or A&B Real Estate Lawyers, or Dirt Lawyers. I'm not sure anyone would want dirt lawyers, but likewise, a law firm may use and practice under a trade name such as Albany Personal Injury Lawyers, if the firm practices Albany, and its practice includes personal injury. Now, this is important, and the rule itself and the comment make clear no trade name can be false, deceptive, or misleading. And again, just a part about a section of the comment that explains that. Comment 11 to the rule says, neither trade names nor domain names may be false, deceptive, or misleading. A law firm may not use a trade name such as, quote, win your case, or a domain name such as www.winyourcase.com, because those names imply that the law firm can obtain a favorable result regardless of the facts and circumstances. One caveat to the rule that, in fact, when the rule came up for debate at the State Bar, the proposed rule from COSAC would have allowed a law firm name to include the names of non-lawyers as part of this rule change. I objected to that. Several others objected to that. The State Bar didn't adopt that proposal, and the Fourth Department, in fact, or pardon me, the appellate divisions did not, and included in the new rules a specific rule that says a lawyer or law firm may not include the name of a non-lawyer in its firm. So the trade name's okay, non-lawyer name's not okay. All right, so explaining the process to you a little bit, now let's talk very quickly about the most common charges of professional misconduct. What are the things that can most likely result in you having to go through this process? Neglect. We've already heard about Rule 1.3 and 1.4. Or we heard about 1.3 is the diligence. 1.3a, a lawyer shall act with reasonable diligence and promptness in representing a client. And B, 1.3b, a lawyer shall not neglect a legal matter. 1.4 is communication. Lawyers shall keep the clients reasonably informed and shall promptly comply with the client's reasonable request for information. All right, so violation of those two, not returning client calls, not advising them of what's happening, misrepresenting what's happening to them, those will get you in trouble very quickly. Trust account violations will get you in trouble very quickly. Rule 1.5 is the main rule about trust accounts. There are others. It's very complex. There could be a whole seminar on that, so I'm not going to do it. The very short version is, if you're in possession of money that is the client's money, or as Paul Isaac mentioned, is another person's client, the other side, something like that, it must be kept separately in an account labeled attorney special account, attorney trust account, or attorney escrow account. I know a lot of lawyers, if you go and look at your trust account, it's probably labeled IOLA account, which stands for interest on lawyer account. Banks automatically will set up accounts under that name. That's not the proper name. Under the rule, it has to be under attorney special account, attorney trust account, or attorney escrow account. The name isn't all that important. What's important is you have the account and that you maintain the money there separate from any of your money, and that you not use it for any purpose other than what the client has approved that you use it for. And also the other part of 1.5, quick summary, is you have to maintain your records regarding all of those financial matters for 7 years. So to summarize these two things, return your clients' calls, keep them apprised of what's happening, and keep your trust account protected and sacred. All right. Aggravated and mitigating factors. I don't want to talk a lot about this. There's a whole list I put in my materials. Many of the different things that have been considered aggravating or more important to me, mitigating factors. The ABA has issued a document called the Standards for Imposing Lawyer Sanctions. I have for years cited those standards and what it says about what should be considered as mitigating factors in my submissions to the court, and usually would get eye rolls or just yawns in terms of citing an ABA document. The new rules that I talked about that were issued in 2016, the statewide uniform rules for attorney discipline, actually advise the court that it should consider the ABA standards. So again, that's a positive development. They're laid out there, and they're things that you should cite. Other topics of interest quickly: no statute of limitations. No, that's what it is. That they can bring an attorney grievance matter or disciplinary matter against you for something that happened 10, 15 years ago. It doesn't happen often, but there's no statute of limitations relating to a disciplinary matter. Duty, Alexander, do I have time to do the, I'd like to do the Galasso case if I can. Is that all right?
Yeah, we've got a few more minutes, man.
Okay. I want to be respectful of everyone else's time. So look at Rule 1. So duty to supervise employees and associates. You have responsibilities for what other lawyers and staff people do at your law firm. That's the easiest way to say it. Specifically under Rule 5.1 and 5.3. And I encourage you to read those. Those are the operative rules. 5.1 has to do with whether you're responsible for what other lawyers in your firm do. And 5.3 has to do with supervising non-lawyers who work in your firm. But the Galasso case is an important case to talk about. And whenever I explain this case to a lawyer for the first time, they keep saying, "You're kidding. That really can't be what happened." So Peter Galasso was a very well-respected attorney down Long Island, New York City area. He was a partner at his firm. He's one of two partners. His brother, Anthony, also worked for the firm, but he was not a lawyer. His brother, Anthony, was the firm's office manager and bookkeeper and had some training in accounting. Peter and one of the other lawyers at the firm were the only two signatories on the escrow account. Therefore, they had the absolute duty under 1.5 to ensure that all trust funds were maintained and proper. Unfortunately, over a 3-year period, Anthony, the non-lawyer bookkeeper, stole over $5 million of client funds from the escrow account of the law firm. He used extremely sophisticated methods, including diverting the bank escrow statements. So you get a trust account or escrow account statement from the bank, and lawyers who are partners at their firm always review those statements and should always review those statements month by month. Anthony actually had called the bank and had the bank send them to a PO box that only he controlled. He would get the statements and he would alter them and then put them back in the envelope and give them to his brother to review. So you can see the sophistication of the method that he used, and to conceal it, actively conceal it from his brother. Anthony was caught eventually. He pleaded guilty to felonies and he was sentenced to jail. The Attorney Grievance Committee then caught wind of this and commenced a proceeding against Peter. It was undisputed that Peter did not steal any money, did not get any of the money. He did not know about the thefts. That was undisputed. And that the scheme was very sophisticated and specifically designed to prevent Peter from ever finding out. And Peter testified, I looked at the escrow statements every month and they were seemed to be completely proper to me. Nevertheless, after a hearing and then back to the second department, which is the appellate division that where he's practicing, he was found guilty of several charges of misconduct, mostly related to 1.5 violations of trust accounts, and 1 count of failing to cooperate with the Attorney General, or the Attorney Grievance Committee investigation. He was suspended for 2 years. Many people thought that was too severe. You may think it's too severe. He actually appealed to the Court of Appeals, which is very rare. Attorney disciplinary matters are normally not appealable because they don't raise issues of law. But in any event, he filed a motion. His motion was granted. He had an appeal to the Court of Appeals. There's a lot of interest in the case, a lot of publicity. Several bar associations filed amicus briefs supporting Peter. The Court of Appeals ended up affirming the finding that Peter was guilty of 1.5 violations, that he was guilty of those violations not because his brother stole money, but because he failed in his duty to preserve the trust funds and to supervise his employee. But in what was assumed to be a signal to the second department that maybe its sanction was too severe, the court found that Peter had not failed to cooperate and sent it back to the second department with a request that they reconsider what what discipline would be appropriate. It was a unanimous decision from the Court of Appeals, so many people assumed the second department would reduce the sanction, the discipline. On remand, however, the second department said, thanks, yeah, we meant what we said. This deserves a 2-year suspension, and they suspended him for 2 years. Good news is he was eventually reinstated. He's now practicing. Final thing I'm going to say, because I know Alexander is signaling to me really quickly, representation by counsel. I'm just going to say it. It's my opinion. Don't represent yourself. If you ever get a complaint letter, don't represent yourself. The Attorney Grievance Committee has experienced attorneys. They're excellent. They're very experienced about the rules and the procedures. You're already at a disadvantage because you may be trying to learn what the procedures are, read the rules for the first time since law school. In addition, you will be personally compromised. You will be emotional. You may be angry. You may be distraught. You may be upset. Your instincts may be to fire back, say in your response that this client was a louse and no good and never even paid me, or fall on your sword too quickly for things that really you shouldn't. Either of which could be the wrong strategy. You need dispassionate advice and advice from someone who's knowledgeable and experienced in these. Judge Bellardo and I, when he was not Judge Bellardo, but just my partner Larry, wrote an article about this, and that's one of the attachments in the appendix to my materials about what it's like to represent lawyers and why they shouldn't do it themselves. I want to mention one thing about the cost. If you have malpractice insurance, and I hope all of you do, but if you have malpractice insurance for yourself or your firm, you have coverage. Every malpractice policy that I'm aware of in New York State has coverage for counsel to represent you in a disciplinary matter. because the insurance companies know that a disciplinary matter can turn into a lawsuit, and they want you to be represented. So you are likely to be able to get counsel and it be at no cost to you, but it'll be assumed by your malpractice. I included two other things in my appendix that are materials from one is from the ABA and one is from the Pennsylvania Bar Association that talk about ethical duties in the times of a pandemic or other disasters. And the other speakers had already spoken about this. You still have a duty to communicate with your clients. You have a duty to be competent with technology, so you have to do that. And you have to do it in a way to maintain their confidentiality. So thanks, sorry if I took too much time, and I'll wait till the end if there are any questions.
Thanks very much, Vinny, that was great. Our third course code is grievance. I'll type this into the chat room in a minute. And our next speaker is Chris Trapp, a partner at Greco Trapp PLLC. Chris concentrates his practice in municipal law, labor law, education law, and civil litigation, including general commercial litigation. He obtained his undergrad degree at Syracuse University and his law degree from UB. He is admitted in both the state and federal trial and appellate courts throughout New York State, including the Second Circuit Court of Appeals. Chris has argued over 150 appeals before the Appellate Division, the Court of Appeals, and the Second Circuit Court of Appeals. In 2010, Chris was admitted to the bar of the United States Supreme Court. He was appointed by the county executive for the County of Erie and approved by the Erie County Legislature to the Erie County Board of Ethics and is currently the vice chair of the Ethics Board, having served in that post for the past 5 years. Chris is a member of the New York State Bar Association, where he currently serves as chair of the Municipal Council Committee and a member of the Professionalism and Ethics Committee after previously serving as co-chair of the Labor and Employment Committee. So with this, I'll turn it over to Chris.
Good morning. Hopefully everyone can see me as I'm working with multiple screens here. Although I'm not all that well versed in computers, so I will be having the assistance of Joe, who will be handling the screen aspect of it. And for those of you who aren't terrified after what Vince mentioned, what he talked about was good to know and very important, especially for newer attorneys as they begin their careers in this field. You never want to get one of those letters, and he is quite correct in that regard. But we're here right now to talk about ethical considerations for government attorneys. Now, this is not for everyone, but there are enough people out there where this should come of some interest to you. And the first question is always asked: who is the client? You have, and I will speak from the terms of, as my example, a village board. A village board is there or then of a series of department heads. To whom do you owe loyalty? To whom do you answer from an ethical standpoint? And the answer to that is not as easy. You may think, well, I got appointed by the mayor, approved by the Board of Trustees, but who am I really responsible to? And the answer is the organization. It's not to an individual member. If you work with school districts, you'll find that you're dealing with a lot of different stakeholders. Again, you'll have the superintendent, you'll have Board of Education members, and you will have the children of the school district among all the other stakeholders, employees and whatnot. But your duty lies to the organization as a whole. Now, when we talk in terms of an organization as a whole, and you'll see it on the next slide, that may be some different entities. The organization may be the entire government body, but you will have the legislature, you will have the executive branch, and in many instances you may even, although they're governed more by OCA, Office of Court Administration, than a local municipality, you will have a village court or a town court or something else that you will also occasionally get questions from. But you have to remember that your responsibility, again, is to the whole group. If you work only for the legislature, then obviously it is just for the particular legislature. The actual Rule 1.13, as you'll see on the slide, a lawyer is employed or retained by an organization, represents the organization acting through its duly authorized constituents. The constituents, obviously, in this instance, with a village board, you're talking about a board of trustees. With a town board, for example, you're talking about the town council, or if it's a county, you could be talking about the county legislature. Remember, all of these rules that you're talking about when you're talking about government are going to apply whether it's a local government, a county government, or state government, or even a federal government. It is still the organization as a whole. The next slide. The client-lawyer relationship, as municipal attorneys, as government attorneys, sometimes we're not allowed to have true opinions of things. And what we have to remember is that the lawyer has to abide by the client's decisions regarding the objectives of any representation, whether or not you necessarily agree with those, because obviously you're dealing with politics as politics can be. But when the ultimate decision is made, you must follow that representation, whether or not you agree with it. There are caveats to that, and we'll talk about those in a moment. But generally speaking, you must follow what they say. Now, the caveats to that, as you'll see, after you've consulted with the client, you take action on their behalf as authorized to carry out their representation, abide by their decisions, whether it's a settled matter or not. Your representation of the client includes representation by appointment, is not necessarily an endorsement. You don't have to believe it. You don't have to believe it from a political standpoint, an economic, a social, or even a moral standpoint, what they're doing. But as long as legal, you need to follow that particular representation. Now, you can limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. What do we mean by all of that? What we mean is simply talk to your client. Let your client know what the issues are. Let your client know that these are the concerns. Get their informed consent. It's not terribly dissimilar from a medical procedure. If you're going in, one of the things in a malpractice case, you're going to ask, was there informed consent? Did the patient, or in this case, the client, know what was going on? Did you tell them? If you did, and they still proceed along those lines, that's absolutely acceptable under the rules, under Rule 1.2. Now, the exceptions to that are obviously you can't tell your client to engage or help you engage in something that you know is criminal or fraudulent. That doesn't go to the level of helping someone or representing them with regard to their particular issue. If you know it's criminal, you know it's fraudulent, you cannot ethically engage in a course of conduct that is going to fall within those lines. Now, what you should do is you talk to your client, counsel your client. Remember, that's part of our job. It's attorney and counselor at law. The attorney part we're all trained to deal with. It's the counselor at law that's so critical, especially when you're dealing in the government sector, because not everything is litigation. And so you must be in a position where you can see your client to make good decisions, to make a good faith effort to determine exactly what's going on and how does the law apply. What are they doing that's valid or sometimes invalid, and you have to deal with that. Next slide, please. Please remember, we've all heard the statement, the sum of whole is the sum of all of its parts. Well, all those parts may not be the whole. And what you really have to do is advise the people. If the interests of the organization, you will have this, where the government organization as a whole may differ from that, their interests may differ from that of the people making some of the decisions, you have to advise the people making the decisions that you don't represent the individual constituent with regard to a matter unless the group as a whole gives you approval to do that. Let me give you an example, because it has happened to me on more than one occasion, unfortunately, over the years. With regard to a school board, for example, you may have a particular school board member of a group of 7 that is not, shall we say, playing nice in the sandbox. And issues arise with regard to claims being brought against that particular board member. Well, you don't represent that particular board member unless the rest of the board tells you you represent that particular board member. Otherwise, you represent the whole school district, the whole Board of Education, and you cannot, from an ethical standpoint, just represent that one individual member of the board. All right, let's say you've advised people. Then what? You should really at that point tell people, get your own attorney. Conflicts exist because you're dealing with people. You're dealing with different people with different perspectives. If you have a situation where you believe that a conflict exists or that it is impossible for you as the attorney for the organization to represent these disparate situations, tell them. Tell them that they may wish to retain their own attorney. You have to also advise them that, look, if you talk to me and I don't represent you because I represent the entire organization, that may be a situation where it's not privileged. No attorney-client relationship exists, therefore no attorney-client privilege exists. That privilege belongs to the organization, and it's only the organization that can waive that particular privilege. What's that mean? It means a single board member cannot do that. A single board member cannot say, "Oh, that's okay, go ahead. You can talk to the press, you can do this or that for the entire organization." No, that is not how it operates. A single board member, whether it is a school board, whether it's a village board, whether it's a town board, that single board member does not have the right to waive the privilege for the entire organization. Only the organization can do that, and it's only after they have formally acted on it and given you specific instructions in that regard. And I encourage you, whenever you do anything, there's 2 things I always tell people when they start working for me. 1, nothing ever leaves this office without a copy. Second thing, put it in writing. If you want to maintain something, if someone gives you a direction, if your client gives you a direction, make sure that you've got that direction in writing in the event any questions come up later, especially when you see that with government. There's another thing you can do, and that's called reporting it up. In other words, what does that mean? Well, if you know that somebody associated with the organization is engaged in an act or intends to do something or refuses to do something that they've been done where it's going to harm the organization, be a violation of law, especially a violation of law, or some other legal obligation of the organization. If they're not listening to you, kick it upstairs. If it's a member of the board of trustees, talk to the mayor. If it's the mayor, you may have to take it elsewhere, but take it somewhere else. The buck doesn't stop with you; it stops further up. The ethics codes require you to take it up, especially if it's likely to result in a substantial injury to the organization, which means you're going to have to make a determination whether or not it's going to affect the organization and how it's going to affect the organization. The lawyers required to proceed as is reasonably necessary in the best interest of the organization. Again, we get back to who is the client? The client is the organization. If you think that it's not necessarily a bad thing or simply a matter of opinion and not something which will harm the organization, then you may not necessarily have to take it up any further. It specifically says in determining how to proceed, the lawyer shall give due consideration to the seriousness of the violation and its consequences, the scope and nature of your representation. Are you representing everyone or not representing everyone? For example, if it's something from the Department of Public Works or the Highway Department, who are you really representing? The responsibility in the organization and the motivation of the person involved. Are they doing this and knowingly doing what they're doing, or are they simply misinformed because they don't have enough facts, or they just don't know? Well, that comes into the counseling part again in terms of telling them. You have to look at what the policies of the organization are concerning such matters. Perhaps the organization already has a policy manual. Most municipal governments will have policy manuals. They will have ethics codes. They're required to have ethics codes in place. Look at those. They will be a guide for you in terms of the way things should operate in the future. Remember, anything you do should be designed to minimize disruption and to the organization. But what you also have to remember is you have to avoid the risk of revealing any information relating to the representation to people from outside the organization, which takes us to, after you're reporting up, what can you do? Well, suggest to them that perhaps there's another method to operate. Ask them to reconsider the matter. If that doesn't work, advise them that they should get a separate legal opinion on the matter. And that can be sought there are a lot of state organizations out there. NICOM, New York Conference of Mayors, deals with cities and villages and can provide legal assistance. There is one for the Association of Towns, for towns, even the Bar Association, and there is a local and state government law section. You can contact them. They have individuals who will be more than happy to assist everyone in terms of providing a legal opinion to you. I have used them and they've been very helpful over the years. In fact, at the end of this presentation, you're going to see 3 photographs of friends of mine over the years who have helped me along and have given me insight and even helped me with this presentation in the context of, I actually sat there and listened to them at all those seminars I went to all those years, which I will not admit freely that it's been a lot of years, but we'll let it go at that. All right, if you have asked them to reconsider, and if you've advised them to get a separate opinion, and after you've referred them to someone else in the higher authority, if none of those work and they don't listen, and that happens, if despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization insists that you do it or that you refuse to do it, and that is clearly a violation of law and is likely to result in substantial injury to the organization, then and only then may you either A, reveal confidential information if it's permitted under Rule 1.6, and we'll chat about that in a moment, or you may resign in accordance with Rule 1.16. You really don't want to get in the position of having to resign in accordance with Rule 1.16, so I urge you to do everything you can to either ask for them to reconsider the matter or get a separate legal opinion. And sometimes a separate legal opinion is most helpful and the preferred method. So let's go to Rule 1.6, confidentiality of information. You've already heard about that at great length, I'm sure, from all of the other speakers. The same applies in the government setting. You shall not, it's not, you may not, it's not, you can think about it. No, a lawyer shall not knowingly reveal confidential information or use such information to the disadvantage of a client or for the advantage of a lawyer or any third person. In other words, do it for the organization that you represent. Now, what are the circumstances in which you can provide confidential information? One, client tells you, gives you informed consent as defined in the rules. Or two, the disclosure is implicitly authorized if you're trying to advance the best interests of the client. And it's either reasonable under the circumstances or customary in the professional community. That requires you to do something more than just simply tell someone else. You really have to look at whether or not it's reasonable under the circumstances. Should I really say this at this point? Or how will it affect the organization if I do it? Have I done everything I possibly can to get them to change their position if I truly feel it's illegal? Have I asked for assistance from outside? Have I gone up? If you've done all those things, and it's something that we as attorneys would normally do, and that may include, and I have done this in the past, I've even gone to other judges and said, look, I have this situation, what do you think? I just want to make sure that everyone's on safe ground, which will necessarily result in some disclosure. That would be something which would be customary in the professional community to reach out. If all those things, the disclosure is going to be something which is permitted under the law. Now, is everything confidential? No, not everything is confidential, especially in the government arena where you have the Open Meetings Law, you have Freedom of Information Act where you're supplying information. You have heard repeatedly, and you will probably continue to hear the phrase transparency. That truly exists. You have a committee on open government whose sole function is to make sure that government is open and transparent and supplies information, which means that not everything is confidential. But under the ethics rules, confidential information does actually exist. And it consists of information gained during or relating to the representation of a client, whatever its source. Doesn't matter where you got it from. If it's something which you got as an attorney representing that client, in this case, the organization, then it can be protected by the attorney-client privilege. Is it confidential if it's also confidential if it's likely to be embarrassing or detrimental to the client if disclosed? No rumors, no side stories about people, or information that the client has requested to keep confidential. Now, you will have from time to time in government, you will have people asking specifically that it be kept confidential. Your job as an attorney is to abide by that request. Now, confidential doesn't include your own legal knowledge or your legal research. That's not confidential information necessarily. Obviously, what you tell your client in terms of giving a client direction on how to proceed, that type of legal advice, that is something which is protected and something which, unless your client tells you to tell the rest of the world how you're going to act in a particular manner, litigation comes to mind immediately, that would be confidential. If it's information that's generally known in the local community, that's not confidential either. So if it was discussed in open session, and remember, we have two types of meetings. We have the open meetings governed by the Open Meetings Law, and we have executive session meetings. And executive session meetings are very specific in terms of what they can entail. It's set out specifically in the statute saying, okay, you can have it for certain personnel negotiations items, whether it is for a labor contract or whatever. And I'm not going to, that's as a subject of another very long seminar dealing with what truly is an executive session and how do you call those. So if you want to chat later, we can do that. But those particular things are things you need to remember. If you're going to err on the side of keeping the information confidential. Now, but when it's confidential, is it really confidential? A lawyer may reveal or use confidential information under Rule 1.6 again, to the extent that the lawyer reasonably believes it is necessary to, one, prevent reasonably certain death or substantial bodily harm. That's pretty self-explanatory. If you feel that someone is going to be physically injured or certainly die, yes, that's the time to tell. That's from the law school time, your client comes in and tells you, I just killed someone. Well, that's different than your client coming in and telling you, next week I plan on shooting someone. In the first instance, you have the responsibility to keep that confidential. The second, really a bad idea not to mention, obviously to the client that that's a bad idea, but also to someone else to protect the interests of the third person who might be killed or harmed. Second thing, when it's not really confidential, it's to prevent them from committing a crime. Again, I know I'm going to be embezzling something. You can't keep that confidential. That's not protecting the interests of the organization. And you are not required to do that. Third instance is to withdraw a written or oral opinion or representation previously given by you and reasonably believed by you to be relied upon by a third person, where you've subsequently discovered that, oops, it's based on an materially inaccurate information or is being used to further a crime or fraud. You cannot hide behind the guise of, well, I gave you this written opinion. No, if you know that it is going to be used illegally, or if you learn that something later is changes that, as painful as that may be to say, oops, things have changed, you have a responsibility to make that no longer confidential. Again, that's a matter of keeping your client informed and talking to them. Communication, like a marriage, is the most critical thing. when you're dealing with ethics and government on behalf of the government. Now, when also is something really not confidential? Well, if you're trying to get legal advice about compliance, either with these rules or any other law by a lawyer or someone else associated with your firm, for example. Many times, if you're a solo practitioner, it's a little more difficult. You don't have someone to bounce ideas off. But if you go and talk to one of your other partners or one of the other attorneys in your office, you're not violating any confidentiality rules under the ethics codes. It's also that also includes defending the lawyer or the lawyer's employees against an accusation of wrongful conduct. And the catch-all is that when permitted or required under the rules to comply, or if you get a court order to that effect. You get a court order, and many times you can ask the court for that type of direction. Please feel free to tell me to tell somebody. Then that is acceptable under the rules. Now, and you will see this, although they probably do it digitally now, and they don't do it quite so much with the old, probably people don't have tapes on their desk anymore. But can a lawyer secretly tape a conversation? So now, in New York State, as long as someone is a participant to a conversation, it is legal to tape that conversation. Having said that, what may necessarily be legal doesn't necessarily make it a good idea. You'll see there that we have provided 3 opinions, ABA opinion, and 2, one from the New York State Bar Association, one from the New York City Ethics Committee, that while you may be able to legally do it, it's frowned upon and discouraged from the standpoint of your legal ethics. In the New York State Bar Association one, you will see that they said, look, and even if a secret recording or conversation is not illegal, it offends the traditional standards of fairness and candor that should characterize the practice of law. There are disputes of that. You see that referred to in the New York City ethics opinions. But if you read each one of these, you're going to come out with the same basic theory. Yes, I can do it, but really it's a bad idea, and try not to do it. Next slide. Thank you. The ethics opinion continues on in terms of secretly taping conversation. And it says, while the committee concludes that there are circumstances other than those addressed in our prior opinions, which you may tape it, we adhere to the view that undisclosed taping as routine practice is ethically impermissible. 2 things about that. You're going to see undisclosed taping. Obviously, if you tape the conversation, you tell the other individual you're taping it, then that's not undisclosed and not a violation of the ethics provisions. But the other thing is, as a routine practice, and that was an interesting phrase that they use, routine practice, indicating that if you're doing this all the time or pretty much all the time, that's established as a practice. What happens if you have this one particular matter and you want to tape it because you just something about it from a government standpoint? Is that something which is impermissible? Well, they didn't address that specifically, but they did say attorneys should carefully consider whether a conduct, if it became known, would be considered by the general public to be fair and honorable. The basic standards: what is fair, what is honorable, and those are the things that should guide our particular practice. And I submit to you, guide our practice all the time. Now, Rule 1.7, again, as it applies to government attorneys, except as provided for in subparagraph B, and you'll see that throughout all of these, throughout the entire presentation. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. And when does a concurrent conflict of interest exist? If you have one client, the representation of one client will directly be adverse to another client, or if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third party, or by personal interests of the lawyer. All right, conflicts of interest. The personal interest of the lawyer is fairly straightforward, and we'll talk a little bit more about that later. But when you're dealing with a government, how are you really dealing with multiple clients? Well, you may represent more than one municipality. That is not uncommon. What do you do when the interests of one, for example, let's say you represent a town board, and you've got a school district that you also represent within that town. Instances can occur where you will have a conflict between what the school wants you to do and what the town wants you to do. What do you do under those circumstances? If it's not something that the parties can sit there and agree upon a waiver, then you either bow out or you get someone else to represent the other party. You cannot represent, you cannot serve two masters. You cannot represent both of them at the same time. It does not work. That's where there's a significant risk that one or more clients will be materially limited by your responsibility to the other client. Next. Now, if you do have that type of concurrent conflict, you can still represent a client if you reasonably believe you'll be able to provide competent and diligent representation to each affected client. Again, I recommend that you make this conflict known to everyone. Representation isn't prohibited by law. Representation doesn't involve an assertion of a claim by one client against another. You can't go suing your own clients. That's really a no-no and a bad idea. But one thing you can, and it's actually number 4, each affected client gives informed consent confirmed in writing. Remember I told you earlier about talking to your client, getting their consent. Informed consent means more than just a short overview. It means talking to them, letting them understand what the problem is and how to deal with it. And then if they still want you to do it, get it in writing from both of them, not one, get it in writing from both of your clients. That is what you're required to do under Rule 1.7. Now, you have as part of, because what you have to remember, and it'll be on the next slide, remember that you have the attorney-client privilege that you need to deal with. And you'll find that referred to in our own CPLR section 4503, and I haven't repeated it here, but you will also see it in the restatement 3rd of law governing lawyers and attorney-client privilege. And I urge you, and I did it as part of the research for this, actually looking at the restatement 3rd of law, and I provided the site later on to it. It's actually a fascinating read and gives you examples and rather thorough discussion of the attorney-client privilege, among other things, as it deals with the practice of law and your responsibilities. Again, you still have the responsibility as your client being the organization as a whole. If I can just quickly check, and I apologize, Alexander, about how much time is left, so I know.
We've still got a few minutes.
Okay.
We'll get to the Q&A after.
Okay. I didn't have a specific time, so I just wanted to make sure. All right. Now, what is the attorney-client privilege? It can be invoked as provided at section 86 to a communication made between privileged persons, the attorney and the client, in confidence. Not, oh yeah, you can go out and tell everybody. No, it's in confidence and for the purpose of obtaining or providing legal assistance for the client. Now, how do you determine the depth of that privilege? Well, there are really two tests. There's the control group test. That extends only to the employees in a position to control or take a substantial part in the decision about the action. In this case, that would deal with the, again, we'll use the example of a village board. That would be the mayor or the village board of trustees making it under the control group test. That would not be you're having a discussion with an employee who happens to work for the village. That privilege doesn't necessarily attach to them. That privilege would attach to the organization as a whole. Obviously, if you're talking to them as part of your representation of the organization as a whole, as a municipality, then their conversations would be. But simply talking to them generally, that's not part of the control group test. The second is the subject matter test. That extends when you have confidential communications between the attorney and any employee. But it's not just a conversation, it has to have the subject matter of the communication concerning the employee's duties as part of that organization. And the purpose of it is to determine exactly the depth of the privilege. Again, it's not just having any conversation. Is that conversation related to the organization as a whole and what I'm doing on behalf of the organization as a whole to determine whether or not, okay, now, they're not part of the control group because they're not the board of trustees or the mayor, but the subject that I'm talking about is such that it is part of my representation of the organization as a whole. So those are the two tests we're going to deal with. On the next slide, you're going to see, again, the restatement third. And that citation you're going to see at the bottom for any of you who are interested in actually reading the restatement. And again, I recommend it. It is quite interesting. The attorney-client privilege extends to a communication of a governmental organization. Remember, a lot of times people only think of the attorney-client privilege being between you and perhaps a personal client. You're representing them in an automobile accident or in a criminal proceeding. Well, the restatement specifically said that no, this also applies to communication of a governmental organization or an individual employee or someone else in terms of your representation of them on behalf. Now, if you remember earlier, we talked about, well, you can refer something up, you can try to dissuade them, you can give them alternatives, you may be able to provide confidential information outside of the rules. Well, okay, now you're there. And none of those things are working. And sometimes you will find that when you're practicing law long enough. How do you get out? And there's a specific rule for that. Rule 1.16, I referred to it much earlier, and it's declining or terminating a representation. The declining, when you're already a government attorney, the declining is a little more difficult because at that point you've already been either retained by it or you're actually employed by the governmental entity. So really what you're doing then is you are terminating a representation. And it's not a concept anyone wants to ever hear about per se, but from an ethical standpoint, there are times when you must really just do that. As difficult as that may seem, you are required to do that. You are not, except as stated in paragraph C, a lawyer shall not, you can make that decision, shall not represent a client where representation is already commenced and shall withdraw from the representation of the client if the representation will result in a violation of the rules of professional conduct. Again, the things of, doing something illegal, embezzlement, or something similar to that, or the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or if the lawyer is discharged. The lawyer discharges is relatively straightforward. You're fired. Physical and mental condition materially impairs the lawyer's ability. Now, the interesting part of that is if your mental capacity is already impaired, you may not know that your mental capacity is compared to the point where you should not be representing someone. Physical condition, and with all due respect to the ADA, you may not be able to represent someone, whether it be through a physical impairment such as you're deaf and you can't hear what they're talking about at a meeting. That would be a condition perhaps where you would have to resign from representation at that point. Now you can also withdraw, and this is a may, not a shall. You can also withdraw a represented client if it can be accomplished without adversely affecting the interests of the client. What that means is it's much easier to withdraw earlier on than later, because later and the more work you put into it, you may have a greater chance of materially having an adverse effect on the client. 2, you can withdraw if the client persists on a course of action that you believe is criminal or fraudulent. 3, they're using your services to perpetuate a crime or a fraud. And you'll see this, one of the basic things. And I know they said in here, in terms of it, you may withdraw. I submit to you that you should and must withdraw because of all of the earlier rules that we've already talked about in terms of what a lawyer can and cannot do in terms of criminal activities. Or you can withdraw if the client fails to substantially fulfill an obligation. You'll see that a lot when you have clients you've asked for documents, or you've asked for a response, or you need to provide this information to me so I can adequately represent you, and they just don't, and they don't, and they don't. That is a situation where you can get yourself removed. If, and this is a little more difficult, representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client. The unreasonably difficult by the client, again, the reasonable standard is a little easier to argue. Unreasonable burden on the lawyer, financial burden on the lawyer, I submit to you would be a little more difficult, especially when you're dealing from the standpoint of a government attorney. And of course, the catch-all other good cause for withdrawal exists. Now, what do you do once you have withdrawn, or you've made the motion to withdraw? Aside from, obviously, if you're in a litigation and you're a government attorney and you're involved in litigation, you must notify the court. It may even involve a motion to withdraw. But until you get that order, until you have the understanding with the client, you'll have to continue representing them for good cause. Now, what happens after you get out? Well, you don't lose the attorney-client privilege. It doesn't mean all of a sudden things are no longer confidential. What it means is you still have to take steps reasonably practical to protect the client's interests. You give notice to them, give them time to find somebody else. You give the papers to the new attorney or to the client. Those are the types of things you have to do to give them an opportunity to protect their interests. And in the government, that will mean making sure that you're assisting the other attorney who is going to be taking over the claim on behalf of the municipality. Now, conflicts of interest, and
Just a quick time note. If under 10 minutes left.
under 10 minutes.
Yep.
Well, I hopefully only have 10 minutes left. I will do what I usually do and talk really fast. And I apologize in advance. Conflicts of interest. There is an entire article under the General Municipal Law, Article 18, which governs conflicts of interest involving municipal employees and government attorneys. And I've only defined one thing here, section 800-803 defines an interest as a direct or indirect pecuniary or material benefit accruing to a municipal officer or employee as a result of a contract with the municipality which such officer or employee serves. Let's talk about that. Contract. You can have a contract with a spouse, minor children, dependents. For example, if you have you're representing a municipality and a spouse has a business, and the business, either through bid or otherwise, wants to engage in a contract with the municipality, two things happen. One, as the attorney, you're not necessarily making that decision about whether the municipality engages that client, but the municipality certainly needs to know that that familial relationship exists under the law and under the ethics rules. Again, that goes to the notice. Now, where as a municipal attorney might that come up? And think, well, I don't make the decision. That's the municipality making the decision. That may be true, but there are usually contracts involved. And the municipal attorney may very well be either writing the contract or certainly reviewing the contract. Well, in those cases, yes, you do have a direct interest. Do you make sure the contract protects the municipality, or do you make sure that the contract protects the corporation that is owned or run, or where your spouse has a significant interest in it? Your responsibility, again, beyond the simple disclosure, is to either A, have it reviewed by another attorney for the municipality, or B, advising the client that, look, at perhaps this would not work because of the conflict of interest. And it doesn't have to be, again, a direct financial gain to you. It can be something that is indirect. And please remember, a willing or knowing violation of Article 18 is a misdemeanor. Now, we talked in terms of just generally, and I put this on the category of land use and other issues. Again, contractual. Attorney provides outside services to the municipality without bidding or disclosing an interest in a business. Attorneys may have multiple business interests outside. For example, they represent a developer, and they may have a personal financial gain. And you're representing the municipality, but you're also representing the developer who wants to come into the municipality for development purposes. Well, you can have personal financial gain in that, which raises that conflict of interest. You can have a specific contract with an organization. You own another company on top of it. Maybe they provide stenographer services, and they're going to do it for your local court. Well, that's a contractual relationship again. And we already talked earlier about the familial relationships, which is not just your spouse, by the way. It's can also be your children or anyone else who has any type of financial interest or dependency on you. Now, there are different cases, and can you have a situation where the same attorney represents the zoning board of appeals or a planning board while also representing the developer? Or you have instances, and you'll see it on the next slide, what if an attorney only acts as a prosecutor in the municipality? There's a New York ethics opinion that a conflict exists for which no consent can overcome. Sometimes you just can't overcome it when one member of the law firm acts as town attorney, or among other things, planning and zoning matters, and another lawyer in the firm seeks to represent an applicant before the town's planning board. Remember, this is not just your conflict. This issue of conflict extends also to other members or other attorneys in your firm. So it's not okay for you to be the town attorney or the village attorney and having another attorney in your firm to do the work that's coming in. The money all goes to the firm. And you're not going to be able to build some type of a wall to say, oh, well, that's okay. I'm not really doing that. No. It's not just your spouse, it's not just your dependents, it's not just your personal interest. When you're attorney and you're a government attorney, it extends beyond that. Now, I use the example of the prosecutor. Well, if you're only the prosecutor in the municipality and you're only dealing with the vehicle and traffic and other local issues, that may not be the same thing. And you may not have a situation where the conflict of interest would exist. Next slide. Now, you'll have a situation. In this example, an attorney is a member of homeowners association that is suing a municipal board. Is that a situation where you cannot represent the municipality? Or more, you can't have any involvement with the homeowners association? Or what can you do if you have a tax assessment issue and you feel your tax assessment is too high? Can you sue the municipality? The answer to the latter is yes, you can. You really have to look at each individual matter on a case-by-case basis to determine whether or not you have to recuse yourself from the matter. I recommend that you always, as a municipal attorney, disclose any relationships that you have. It is the safest and most ethical way of proceeding. Now, can an attorney file a tax assessment? You'll also see the ethics opinion from fairly recent, only about 6 years ago. Law firm part-time prosecutor for a town may represent a client in an Article 78 proceeding. Again, the relationship between a part-time prosecutor in a town, not necessarily the same thing as a village, so long as the town and the village are separate legal entities and have separate legal departments. And you have nothing to do with the prosecuting of village zoning or planning laws. There are still instances out there. I've attached some particular cases, and I know my time is running short. If we can go to the next slide, please. Attorney drafts the local law, creating a position as a special hearing officer for a municipality and is later appointed to that position. And the question is that just thoughtful retirement planning? Or is this something which is improper? Again, you are only writing the statute. You are not appointing yourself to the position. If you are, there's a problem. But if you're writing the statute, you have a public hearing, it is approved by the municipality, it is filed, it hasn't been challenged, and you subsequently get appointed, is that truly something which is a violation of the ethical provisions? I have listed some other cases of interest, and I've also listed some publications that you may be interested in looking at that talk in terms of attorney-client privileges and that. written. I know Pat Sulkin, who's written a number of wonderful articles, and is a member of the local and state government law section of the state bar. I urge you to look at those materials. Those will be helpful to you. Those are the three people. Special thanks. I've worked with them for more years than I care to really count. They are Mark and Steve have both been co-chairs of the Ethics and Professional Committee of the local and state government section of the state bar. Wade is the general counsel of the NICOM. If you are in government work, you probably already know Wade and have probably called him on more than one occasion, or someone in his office. They are quite helpful down there. And I will look to see if there are any questions.
Thank you,
Or
Chris.
someone will tell me if there are any questions.
Yes, we had a few come in, so I'll let Alex, and then I'll take a few of the ones that came in.
Yep. So
Okay.
before I turn things over to Joe and Meg, who are monitoring the questions, I just want to announce our fourth course code is government. I'll put that in the chat now, and I will turn things over to Joe and Meg for questions.
Perfect. So let's just start, Chris, with you, because we have a question that came in and you just finished. If you recuse yourself from a matter, can you recommend the matter to a different attorney and accept a referral fee?
That would, no, because you're still getting a financial interest in something. You should neither recommend anyone, or a single individual. If you happen to recommend 4 or 5 people that they can, from different firms, that they can make a choice of, that wouldn't be a problem. But you certainly cannot take a referral firm fee from someone on a referral under those circumstances. If you've recused yourself, you should not be involved with the matter at all or taking anything.
Perfect. Thank you.
If I could just add to that, I agree with what Chris said. Also, I encourage people who consult with me not to use the term referral fee. You know, the old concept of you send me a case, I'll send you some money, is really not allowable under the rules. There are very specific conditions under which you can share a fee with an attorney, and you know, we could do a CLE about that. But referral fee concept is just using the word suggests the wrong way to analyze the situation.
Yeah, at that point, you've already said, I have a conflict and I can't do this.
So thank you both. For Paul, I have a question that came in. Not all settlements are in the millions. Do structures make sense for smaller settlements? And what amounts should council consider a structure? Oh, excuse me. And at what amounts should council consider a structure?
Well, I mean, I like I said earlier in my presentation, I think it really does matter on the person. For someone who is, and that's why it's so hard to just throw and dismiss a structure opportunity. It may be a $30,000 case with a client who is Medicaid eligible, and the consequence of taking it in cash may affect their ability to continue to get health coverage. That's an extreme example, but that does happen. I also think that if it's you know, small case like 30,000, 20,000, 15,000, and it's an infant, the CPLR really sort of encourages, 1206 encourages structured settlements even for those small cases. And nobody's making any money on that, right? But it's something that we have to do in order to protect the child, because the money that is held, let's assume that money is $12,000 is put off to the age 25. It escapes all financial aid testing for college. If that child has that $12,000 or $15,000 at the age of 18, you know, it's not going to be horrible, but they're going to have to disclose it on their financial aid application, and maybe some part of it might have to be used. So, you know, so it depends on the case. It really does. And it also depends on the culture and the personality of the people who are getting the money. Some of them want nothing else but to get a home or pay off debt and maintain and preserve their money. Others want to gamble with it. But you don't really know until you present that opportunity to the client in detail. That's all I'm saying.
Wonderful. Thank you. One of the other questions we had come in, and several panelists could answer this, was in the time, oh, sorry, I just had to admit somebody, in a time where inaction is considered violence by many political forces, being a government attorney, being a judge, being a mediator, it requires you to be neutral. How do you remain how do you maintain your neutrality when a position is being inferred upon you by not taking a position? And who would like to take that first?
I'm not sure anyone wants to take that first. But it is difficult. Working with municipalities, there are many times you've heard the old joke, what do you call 10,000 lawyers at the bottom of the ocean? A good start. You just have to have water off a duck's back, I guess, and just ignore it. You have a responsibility from a government standpoint, a municipal standpoint, to represent the municipality fairly and impartially as best you can. And there will be many things out there, especially when you're dealing with government, that will be said one way or the other. And you just have to, soldier on, continue to do what you're doing in the best interest of your client that is ethical and responsible.
I would just add that as a lawyer, so I'm not talking about the role as a judge, but as a lawyer, the rules speak to this point. The rule 1.2 says a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. And, there are some areas of practice that are more familiar with that. People who do criminal representation or, depending on who you're representing, you may not feel they're on the right political or moral side. You still have obligation to represent them and represent them zealously. So I don't abide by the fact that as a lawyer you can be painted with the whatever views your client is espousing. You're there to fulfill a role that is vital to the operation of the justice system.
Just following up on Vince's comments as a judge, sometimes coverage of a decision that you write or something that you issue is misinterpreted or misapplied, and it just kind of goes along with the job. You just have to sort of let that happen. I would recommend that if you do have articles written about you as a judge, not to read the comments following the articles by individuals, because that may drive you crazy. Because most of them are not written by anyone who's actually read your decision or read the transcript of whatever you've decided. So you can get lots of jumping to conclusions, but it's just something that needs to be ignored.
Wonderful. And another question I have, Judge, is this just came in a pre-litigation situation. If two parties and their attorneys want to have a third attorney who practices in that area of law mediate or arbitrate, does that third attorney need to be certified as would be required in litigation, as would be required if litigation had commenced and ADR would be required?
I haven't seen it, Joe, and I don't know the answer to the question. I guess it might come down to like enforceability afterward. But if you're talking about a mediator, I think you could hire, I think two attorneys could agree to a non-lawyer as the mediator. And if they come to an agreement, they come to an agreement. It can be through anyone. So those of you that do more mediation may have a better answer than that.
And I think we lost, unfortunately, Judge Kakavas. I think there was a technical issue, but she did text me and said that if anyone has any questions, I'm free to give out her email and folks could email her as well. I do remember talking with her, though, that in order to do arbitration was more rigidly controlled and you had to be certified by one of those major agencies. And so when it comes to doing arbitration, that would be a major difference between mediation. Though what I did find interesting is the mediation centers. And there's actually one here in Buffalo in Tri-Maine, I've come to find out. do take folks who are non-lawyers and bring them through a program there as well. One of the other questions I had, and actually, Vincent, perhaps you want to take this one first. In a new world where more data is going online and lawyers can write algorithms, and you saw this originally in real estate and with debt collection, you can do a lot where you can do high volume of cases with automation. So you can figure out, you can auto file documents, you can auto bring cases forward. But it also increases the number of errors because computers are not infallible. So how do attorneys the good news is that automation drives prices down, opening legal services to people who otherwise couldn't be served. But the flip side of that is that it also increases error rate, thus increasing issues with attorneys facing the ethics board. So there seems to be some type of balance there, but I have a hard time finding what that balance should be.
Right. So what I would say about that is, and you see that very often in, for example, e-discovery issues, where the old days you had a box of documents and the lawyer rolled up his or her sleeves and spent all weekend going through them and putting little Post-it notes on it. Now, there are reams of electronic documents, and it's very common to use algorithms or use outside consultants to run searches for keywords, things like that. Again, that's a whole seminar about how those things are done. But to get to the question, what do you do about the error rate there? So the first thing I would suggest is you need to have a complete understanding with your client first, how it is you're going to do whatever task it is, or what technology you're going to use, and be upfront with your client about what the chances for error are in that. And compare, many clients are concerned about the cost. Compare the cost. If I review every document by hand, it's this. If we use this algorithm, we can save so much, but it has this type of error rate. If your client agrees to it, then that, in my mind, you fulfilled your duty to your client. And it's hard for later on the clients to claim this was done improperly if they receive full information about how you proposed to do it. Now, you also have the other side and or the judge who may say, well, Mr. Doyle, you only turned over 100 documents and it turns out there's 1,000 that you missed. And again, I would recommend, and I do this often, when I make a production to the other side, I tell the other side how we went about it. These are the keywords we used. These are the documents we searched in this order. And here's the production. And sometimes we'll agree ahead of time. If you get a document demand for any document that's relevant to this case, you call the other lawyer and you say, well, we've got a billion documents and we need to search in some way. Give me your suggested search terms. So in other words, you reach some agreement with the other side about that. And again, it would then be difficult for them to claim something wrong happened. So that would be my first suggestion. And then finally, I would say, in terms of responsibility under the ethics rules, you have a responsibility to be competent, and several people have mentioned this under the rule that 1.1 says you have to be competent. Some other states have adopted within that rule, in the black letter language, a duty to be competent in technology. New York has did not adopt that, but it's in our comments. So the comments that are written by the state bar say that includes a duty to be competent technologically. So I think especially if you're going to take a case that involves a lot of discovery, you're going to have some competence or obtain some competence in areas of, for example, e-discovery.
And I'm glad you brought that up, because we had a question that came in, and perhaps Paul, this would be suited for you because you probably see it more with finance. There's a new ethics proposal out there that a credit be used specifically for cybersecurity. And my experience, when the question kind of phrased it as, you've got folks coming in who are trying to abide by things, but when you're dealing with money and all of that, you're now seeing multi-factor authentication. You need a cell phone and a computer. You have all of these layers that they're bringing in for cybersecurity to get things done. where is the line on that? Where is the line from people being able to actually participate, to see the money is in their account, or be able to understand, get the resources they need to participate? And I was wondering if you had any thoughts on that.
Well, I think that Judge Nowak would be very disappointed in my computer skills. So hopefully I won't have to present in front of him again anytime soon. But because of that, because I'm a dinosaur, I love technology, but nothing aggravates me more than I have, financial services license, securities licenses, and those websites make you change your password about every time I need to go in, right? Automatically change your password. I think anytime that you're touching a social security number and a dollar amount, an account statement, whether it be an investment account, any kind of medical transmissions, every medical document that we get into our office for handling a lien, we ask constantly to dump it into our encrypted box, and that box will come back to us encrypted. And it's a whole nother layer of cost, but frequently we'll have attorneys just send over, the Xerox copies of their the medical records for the clients. And we have multi-layer authentication here because of the number of social security numbers and the medical records that we have. And it's aggravating, but I think there's no end in sight to that. I think it's only going to get worse. These automatic, password development tools that some of the websites have, like, okay, we're going to just set your password for you, and then your Google will remember it, and so on and so forth. Those are great and helpful as long as you know how to save them on your computer. And I know all of you, most of you out there know how to do that, but it truly is aggravating. I don't know if there's any end in sight. I'd expect it to get much worse before it gets better, because, who on this program doesn't get a phishing expedition, or whatever they call phishing, PHISHING, on their computer once a week. Hey, you're an attorney, or hey, Mr. Attorney, I've got a client that has thousands of cases that they want to send to you. Just click right here and or send us an email. Every day there's something out there attracting us, and that's one side of it. And then the other side of it, of course, is when you're searching for something relating to technology on the website, you need support from Brother Computers. You go onto the website and you think you're clicking on Brother, and you get another company that is just ready to take your information. That happens too. So it's so easy for them to get into a computer and ruin a bunch of people's lives. It's one of those things that we have to either tolerate or get out of the business. I mean, it's going to be there, and it's going to be there forever.
Fair enough. Thank you, sir. Alex, do I have time for one more question?
It's 12:30, but we can squeeze in one more quick one.
All right, perfect. So this will be our last one, folks. Something came in that I really thought we should address. It comes down to systemic risk. Basically, with so many more cases entering on the docket, and when lawyers are trying to bring cases and pick a venue, the result of the ADR program is that the cases that are on the docket when they go to ADR go off the docket. And the person who brought the question said this is kind of like Enron doing off-balance sheet transactions. Are we really just hiding how crunched the system is? And so when it comes to the attorneys on here, how are we supposed to deal with this with choosing the proper venue? And when it comes to our kind judges on here, is this really a problem that the bench is paying attention to, this possibility of a hidden depth of a docket that isn't easily recognizable? Who wants to take that first? Oh, hang on, Judge Nowak's talking, but I think, yep, sorry. How about there? There you go, Judge.
That works.
Okay.
Thanks, Joe. It depends what we do with a case. If a case is going to arbitration, that's considered a settlement, even though it's something that I suppose could fall apart before the arbitration. But it's considered that's considered resolved, comes off the docket. It could be resurrected. But whenever I send a case to mediation, whether it's internal within the court system or even external, the case remains on my docket until it's resolved. And so what I'll have is, I'll send a case to a mediator and I'll say, all right, we're going to check back with me in 120 days. And of course, only if the case doesn't resolve. If it resolves, send me an email, that kind of thing. But there's a conference on my calendar, and if it's a 2018 case, that time is running. And I'm basically, as a judge, taking that time with the hope that, the case is going to resolve. So most of the ADR that I will utilize or refer attorneys to, or attorneys tell me that they're going to, do not remove the case from my calendar. Most of those different types of formats will keep the cases, pending and running from the date of filing, running from the date of the RJI. So whenever I get a list saying this is how many cases you have, NOAC, get moving on your cases, they're on there still.
Wonderful. Thank you, Judge. And if nobody else has any comments, Alex, I think you can take us home.
I think Andrea has some comments.
I just wanted to again thank our speakers for taking the time to join us today and for their very informative presentations. You will be receiving more information about our upcoming CLEs. Our next one will be in March, so please be on the lookout for that. Please be sure to also submit your attorney verification and program evaluation to Pat Warrington so we can get you your CLE credit. And I hope everyone has a wonderful weekend. Thank you.